Paper, Administrative Law and Right to Information Act, 2005. 1. Question 1, Meaning, Nature, Scope, Forms and Growth of Delegated Legislation. Explain meaning, nature, scope, forms and growth of delegated legislation. Nature of delegated legislation. The nature of delegated legislation is multifaceted, combining elements of flexibility, efficiency, and accountability. Its key characteristics include subordinate status. Delegated legislation derives its authority from the parent statute and is subordinate to it. It cannot override or contradict the provisions of the primary legislation. Flexibility. It allows the executive to adapt laws to changing circumstances without requiring amendments to the parent statute. For instance, under the RTI Act, 2005, the central government can amend rules to adjust fees or procedural requirements based on practical needs. Limited scope. The scope of delegated legislation is confined to the powers expressly granted by the parent statute. Any rule or regulation exceeding this authority is ultra vires and void. Judicial oversight. Courts exercise supervisory control over delegated legislation to ensure it aligns with constitutional principles and the parent statute. This was emphasized in Krishna Mohan v. Union of India, Air 2000 SC 1420, where the Supreme Court struck down rules that exceeded the scope of the parent act. The nature of delegated legislation reflects a balance between legislative efficiency and democratic accountability. While it enables swift governance, it raises concerns about potential misuse of power, necessitating robust checks and balances. Scope of delegated legislation. The scope of delegated legislation in India is vast, covering various domains such as taxation, public health, education, and transparency laws like the RTI Act. It serves several purposes. 1. Filling in details. Primary legislation often provides a broad framework, leaving the details to be fleshed out by subordinate authorities. For example, Section 28 of the RTI Act empowers state governments to frame rules for implementing the Act at the state level, allowing customization based on local needs. 2. Technical expertise. Delegated legislation enables experts in specific fields to draft detailed regulations. For instance, environmental regulations under the Environment Protection Act, 1986, are often framed by technical bodies with specialized knowledge. 3. Emergency powers. In times of crisis, delegated legislation allows rapid rulemaking. During the COVID-19 pandemic, the Epidemic Diseases Act, 1897, was used to issue regulations for lockdowns and public health measures. 2.4. Administrative efficiency. It reduces the burden on the legislature, allowing it to focus on policy making while the executive handles implementation. However, the scope is not unlimited. The judiciary has consistently held that essential legislative functions, such as determining policy or enacting substantive law, cannot be delegated. In JK Industries v. Union of India, 2007, 13 SCC 673, the Supreme Court clarified that while the legislature can delegate ancillary functions, it must retain control over the core policy framework. This principle ensures that delegated legislation does not undermine parliamentary sovereignty. Forms of delegated legislation. Delegated legislation manifests in several forms, each serving distinct purposes. The primary forms include rules. These are detailed provisions governing the implementation of a statute. For example, the Right to Information Rules, 2012, prescribe the format for RTI applications and the fee structure. Regulations. These are specific norms issued by regulatory bodies. For instance, the Securities and Exchange Board of India, SEBI, issues regulations under the SEBI Act, 1992, to regulate financial markets. Notifications. These are official announcements or orders issued by the government. Notifications under the RTI Act often clarify exemptions or procedural changes. Bylaws. These are rules made by local authorities or public bodies, such as municipal corporations, under statutory powers. For example, municipal bylaws regulate local sanitation or building codes. Orders and directions, these are specific instructions issued under a statute. For instance, the central government may issue directions under the RTI Act to public authorities for compliance. Each form of delegated legislation serves a unique function, ensuring that the parent statute is implemented effectively. The RTI Act, for instance, relies on rules and notifications to streamline access to information, demonstrating the practical utility of these forms. Growth of delegated legislation in India. The growth of delegated legislation in India is a response to the increasing complexity of governance and the need for specialized and flexible rulemaking. Its evolution can be traced through several phases. 3. Pre-independence era. During British colonial rule, delegated legislation was used to administer vast territories efficiently. The Inri Delhi Laws Act, 1912 case highlights the early judicial recognition of delegated legislation, where the colonial government delegated powers to extend laws to specific regions. The judiciary upheld such delegation, provided it was within the bounds of the enabling statute. Post-independence and constitutional framework. After independence, the Indian Constitution provided a robust framework for delegated legislation. Articles 245 and 246 define the legislative powers of Parliament and state legislatures, while Article 13(3) recognizes subordinate legislation as law. The judiciary has played a critical role in defining the permissible limits of delegation. In Hamdard Dawakina v. Union of India, Air 1960 SC 554, the Supreme Court invalidated a delegated provision that was vague and lacked clear guidelines, emphasizing the need for legislative guidance. Modern developments and the RTI Act. In contemporary India, delegated legislation has expanded significantly due to globalization, technological advancements, and socio-economic challenges. The RTI Act, 2005, exemplifies this trend. Sections 27 and 28 of the Act delegate rule-making powers to the central and state governments, respectively, to ensure effective implementation. For instance, the Central Information Commission, CIC, relies on rules framed under the Act to adjudicate appeals and complaints, ensuring transparency in governance. The growth of delegated legislation has also been shaped by judicial scrutiny. In State of Tamil Nadu v. K. Savanayagam, 1998, 1 SCC 318, the Supreme Court upheld the validity of delegated legislation under the Tamil Nadu Shops and Establishments Act, provided it was consistent with the parent statute and constitutional principles. This case underscores the judiciary's role in balancing administrative efficiency with democratic accountability. Challenges and criticisms. Despite its advantages, delegated legislation faces criticism for potential misuse. Excessive delegation, lack of transparency, and inadequate parliamentary oversight are common concerns. The RTI Act addresses some of these issues by mandating public access to rules and regulations, ensuring accountability. However, cases like Kerala Samsthana Chethuthazhalali Union v. State of Kerala, 2006, 4 SCC 327 highlight instances where delegated legislation was struck down for being arbitrary or exceeding statutory authority. Judicial control and safeguards. To prevent misuse, delegated legislation is subject to judicial and parliamentary control. Judicial control operates through doctrines such as ultra vires, reasonableness, and proportionality. In Indian Express Newspapers v. Union of India, 1985, 1 SCC 641, the Supreme Court struck down a notification imposing a customs duty as it violated constitutional principles of freedom of expression. Parliamentary control includes mechanisms like laying rules before the legislature and scrutiny by parliamentary committees. The RTI Act, for instance, requires rules to be laid before Parliament, ensuring transparency and accountability. These safeguards ensure that delegated legislation remains within constitutional and statutory limits. Interplay with the Right to Information Act, 2005. The RTI Act, 2005, is a landmark legislation that empowers citizens to access information held by public authorities. Delegated legislation under the Act plays a crucial role in operationalizing its provisions. For example, rulemaking power, Sections 27 and 28 empower the central and state governments to frame rules on procedural matters, such as application fees and appeal processes. The Right to Information Rules, 2012, are a product of this delegation. Notifications: the central government issues notifications to clarify exemptions under Section 8 of the Act, ensuring a balance between transparency and national security. Administrative efficiency: delegated legislation enables the government to adapt RTI procedures to evolving needs, such as digital filing systems. The RTI Act demonstrates how delegated legislation can enhance governance by providing flexibility while ensuring accountability through judicial and parliamentary oversight. 5. Question 2. Concepts of administrative law, rule of law and separation of powers. Briefly discuss the following concepts of administrative law. A. Rule of law. B. Separation of powers. Rule of law. The rule of law is a cornerstone of democratic governance, ensuring that all individuals and institutions, including the state, are accountable to laws that are transparent, just, and uniformly applied. In the Indian context, the rule of law is enshrined in the Constitution, particularly through Articles 14, 21, and 32, which guarantee equality before the law, protection of life and personal liberty, and access to constitutional remedies, respectively. The concept, as articulated by A.V. Dicey, comprises three core elements: I. Supremacy of law over arbitrary power, 2. Equality before the law, and 3. The law being a product of judicial decisions rather than arbitrary enactments. Supremacy of law. The supremacy of law mandates that no individual, regardless of their position, is above the law. In India, this principle ensures that administrative actions must conform to statutory and constitutional provisions. The judiciary plays a critical role in upholding this principle by reviewing executive actions through judicial review. A landmark case illustrating this is Indira Nehru Gandhi v. Raj Narain, Air 1975 SC 2299. In this case, the Supreme Court struck down Clause 4 of Article 329A, introduced by the 39th Constitutional Amendment, which sought to insulate the election of certain high offices from judicial scrutiny. The court held that such a provision violated the rule of law by undermining judicial review, a basic feature of the Constitution. This case underscores that administrative actions, even those backed by legislative amendments, must align with constitutional principles. Equality before the law. Article 14 of the Indian Constitution embodies the principle of equality before the law, prohibiting discrimination and ensuring that administrative actions are not arbitrary. The case of Maneka Gandhi v. Union of India, Air 1978 SC 597, is a seminal example. The petitioner's passport was impounded without providing reasons, violating her right to a fair procedure under Article 21. The Supreme Court expanded the scope of Article 14, holding that administrative actions must be reasonable, non-arbitrary, and procedurally fair. This case established that the rule of law requires administrative decisions to be transparent and justifiable, aligning with the principles of natural justice. 6. Judicial precedents as a source of law. The rule of law in India is reinforced by judicial decisions that interpret and expand constitutional guarantees. In Kesavan Bharati v. State of Kerala, Air 1973 SC 1461, the Supreme Court introduced the doctrine of the basic structure, ensuring that the core features of the Constitution, including the rule of law, cannot be altered by parliamentary amendments. This case exemplifies how judicial review serves as a bulwark against arbitrary governance, ensuring that administrative actions adhere to constitutional norms. Rule of Law and the RTI Act. The Right to Information Act, 2005, strengthens the rule of law by promoting transparency in administrative processes. By enabling citizens to access information held by public authorities, The RTI Act ensures accountability and curbs arbitrary decision-making. For instance, in Central Board of Secondary Education via Ditya Bandopad 2011, 8 SCC 497, the Supreme Court held that the right to access answer scripts under the RTI Act is an extension of the rule of law, as it fosters transparency in educational administration. The Act empowers citizens to scrutinize administrative actions, ensuring they align with legal and procedural standards. Separation of powers. The doctrine of separation of powers, as conceptualized by Montesquieu, advocates for the division of governmental functions into three distinct branches: legislature, executive, and judiciary, to prevent the concentration of power and ensure checks and balances. In India, while the Constitution does not explicitly mandate a strict separation of powers, it establishes a functional division among the three organs of the state, as evident from Articles 50, 121, and 211, which emphasize judicial independence. Functional division in the Indian Constitution. The Indian Constitution allocates specific roles to each branch. The legislature, parliament and state legislatures, enacts laws; the executive, president, governors, and administrative bodies, implements them, and the judiciary interprets and enforces the law. However, the Indian model is not rigid, allowing for some overlap, such as the executive's ordinance-making power under Article 123 or the judiciary's role in judicial review. The case of Ramjawaya Kapur v. State of Punjab, Air 1955 SC 549, clarified this framework. The Supreme Court held that while the Constitution does not strictly adhere to the separation of powers, it ensures that each organ operates within its constitutional limits, subject to checks by the others. Judicial review as a check on administrative power. Judicial review is a critical mechanism through which the judiciary checks the executive's administrative actions, ensuring they conform to the Constitution and statutory laws. In SP Sampath 7 Kumar v. Union of India, Air 1987 SC 386, the Supreme Court upheld the validity of the Administrative Tribunals Act, 1985, but emphasized that tribunals must adhere to principles of natural justice and remain subject to judicial review by high courts and the Supreme Court. This case highlights the judiciary's role in preventing the executive from overstepping its authority, reinforcing the separation of powers. Checks and balances. In practice, the doctrine of separation of powers ensures that no single organ dominates governance. For example, in Supreme Court Advocates on Record Association v. Union of India, 2015, 5 SCC 1, NJAC case, the Supreme Court struck down the National Judicial Appointments Commission, NJAC, Act, 2014, as it encroached upon judicial independence by giving the executive significant control over judicial appointments. The court reiterated that judicial independence is a basic feature of the Constitution, essential for maintaining the separation of powers. This case illustrates how the judiciary acts as a guardian of constitutional boundaries, ensuring that administrative actions do not undermine the balance of power. Separation of powers and the RTI Act. The RTI Act reinforces the separation of powers by ensuring that the executive's actions are transparent and subject to public scrutiny. By mandating the disclosure of information, the Act enables citizens and the judiciary to monitor administrative actions effectively. In Namit Sharma v. Union of India, 2013, 1 SCC 745, the Supreme Court emphasized that the RTI Act strengthens democratic governance by empowering citizens to hold the executive accountable. The Act's provisions, such as the appointment of information commissioners, also reflect the principle of separation of powers by ensuring that these bodies operate independently of executive control. Interplay between rule of law, separation of powers, and the RTI Act. The rule of law and separation of powers are complementary principles that ensure accountable and transparent governance. The rule of law guarantees that administrative actions are lawful and non-arbitrary, while the separation of powers ensures that each branch of government operates within its designated sphere, subject to checks and balances. The RTI Act serves as a practical tool to operationalize these principles by enabling citizens to access information about administrative decisions, thereby fostering accountability. For instance, the case of State of Uttar Pradesh v. Raj Narain, Air 1975 SC 865, illustrates the synergy between these concepts. The Supreme Court upheld the right to information as an integral part of the rule of law, emphasizing that transparency in governance strengthens democratic accountability. Similarly, the RTI Act's requirement for proactive disclosure of information under Section 4 aligns with the separation of powers by reducing the executive's ability to act unilaterally without public oversight. 8. Critical analysis. While the rule of law and separation of powers are robustly enshrined in the Indian Constitution, their implementation faces challenges. Bureaucratic resistance, delays in judicial processes, and occasional overreach by one branch into another's domain can undermine these principles. The RTI Act, despite its transformative potential, faces issues such as non-compliance by public authorities, misuse of exemptions under Section 8, and delays in appointing information commissioners. Cases like Anjali Bardwa v. Union of India, 2019, highlight the judiciary's role in addressing these challenges by directing timely appointments to ensure the RTI Act's effective implementation. Moreover, the judiciary's expansive use of judicial review, while essential for upholding the rule of law, occasionally raises concerns about judicial activism encroaching upon the executive's domain. The NJAC case, for instance, sparked debates about whether the judiciary overstepped its role in striking down a legislative enactment. Balancing these principles requires constant vigilance to ensure that administrative actions remain lawful, transparent, and accountable without disrupting the constitutional equilibrium. 9. Question 3. Administrative discretion and its control. Discuss administrative discretion and its control in the light of decided cases. Concept of administrative discretion. Administrative discretion refers to the authority vested in administrative bodies to make choices among possible courses of action within the bounds of law. It is an essential component of modern governance, enabling flexibility in decision-making to address diverse and unforeseen circumstances. For instance, under the Right to Information Act, 2005, a public information officer, PIO, has the discretion to determine whether certain information can be disclosed under exemptions provided in Section 8 of the Act. Similarly, under environmental laws, authorities may exercise discretion in granting permits based on ecological assessments. However, discretion is not absolute. It must be exercised in accordance with principles of reasonableness, fairness, and justice. The judiciary has emphasized that discretion must not be arbitrary, capricious, or mala fide. As observed in State of Punjab v. Khan Chand, 1974, the Supreme Court held that discretion must be guided by reason and law, not whim or fancy. This case involved the arbitrary refusal to renew a transport license, which the court struck down as an abuse of discretion. Nature and scope of administrative discretion. Administrative discretion operates in various domains, including licensing, policy implementation, and enforcement actions. Its scope is determined by the enabling statute, which may confer broad or limited discretionary powers. For example, under the Customs Act, 1962, customs officers have discretion to assess the value of goods for duty purposes, subject to statutory guidelines. The exercise of discretion involves two key aspects: 1. Decision-making latitude, the authority to choose from multiple lawful options. 2. Reasoned application, the obligation to base decisions on relevant considerations and legal principles. The judiciary has consistently held that discretion must align with the purpose of the statute. In Barium Chemicals Limited v. Company Law Board, 1967, the Supreme Court ruled that discretionary powers must be exercised for the purpose for which they were conferred, and any deviation constitutes an abuse of power. Need for administrative discretion. Administrative discretion is vital for several reasons. Adaptability, it allows authorities to adapt to unique or unforeseen circumstances. For instance, during a public health crisis, health officials may need to exercise discretion in allocating resources. 10. Efficiency, rigid adherence to rules may delay decision-making. Discretion enables swift action, as seen in disaster management scenarios. Expertise, administrative bodies often possess specialized knowledge, enabling informed decisions. For example, the Pollution Control Board exercises discretion in environmental clearances based on technical assessments. However, the absence of checks on discretion can lead to arbitrariness, favoritism, or corruption. The judiciary has developed several mechanisms to control administrative discretion, ensuring it remains within the bounds of law and fairness. Control of administrative discretion. The control of administrative discretion is achieved through constitutional, statutory, and judicial mechanisms. These controls ensure that discretion is exercised in a manner consistent with the rule of law, principles of natural justice, and fundamental rights enshrined in the Constitution of India. The following sections discuss these mechanisms with reference to landmark cases. Constitutional safeguards. The Constitution of India provides a framework for controlling administrative discretion through fundamental rights and judicial review. Articles 14, 19, and 21 are particularly relevant. Article 14, Right to Equality. This article prohibits arbitrary action by the state. In Ramkrishna Dalmia v. Union of India, 1958, the Supreme Court held that administrative action must not be discriminatory or arbitrary. The case involved the government's decision to refer certain companies for investigation, which was challenged as discriminatory. The court emphasized that discretion must be exercised on objective criteria. Article 19, Fundamental Freedoms. Discretionary actions that unreasonably restrict freedoms, such as freedom of speech or trade, are subject to judicial scrutiny. In Sagir Ahmed v. State of UP, 1954, the court struck down a transport nationalization scheme that arbitrarily restricted private operators' rights under Article 19, 1, g. Article 21, Right to Life and Liberty. The principle of procedural fairness, including natural justice, is implicit in Article 21. In Maneka Gandhi v. Union of India, 1978, the Supreme Court held that the discretionary power to impound a passport must be exercised fairly, with reasons disclosed to the affected party. This case expanded the scope of judicial review to include procedural fairness in administrative actions. Statutory controls. Statutory controls limit discretion by prescribing guidelines, procedures, and checks within the legislation. The Right to Information Act, 2005, is a prime example of statutory control over discretion. Section 8 of the Act lists exemptions where a PIO may refuse to disclose information, but such 11 refusal must be justified with reasons. Section 19 provides for appeals against arbitrary refusals, ensuring accountability. In Central Board of Secondary Education v. Aditya Bandyopadhyay, 2011, the Supreme Court clarified the scope of discretion under the RTI Act. The court held that answer scripts of public examinations are information under the Act and must be disclosed unless covered by specific exemptions. The case underscored that discretion must be exercised transparently and in accordance with statutory provisions. Judicial control. Judicial review is the most significant mechanism for controlling administrative discretion. The judiciary ensures that discretionary powers are exercised within the bounds of law, reasonableness, and fairness. The following principles guide judicial review. 1. Doctrine of ultra vires. Administrative actions exceeding the scope of statutory authority are void. In Barium Chemicals Limited v. Company Law Board, 1967, the Supreme Court quashed an order for investigation into a company's affairs because the Company Law Board had acted beyond its statutory powers. 2. Reasonableness and proportionality. Discretionary actions must be reasonable and proportionate. In Union of India v. G. Ganayutham, 1997, the Supreme Court adopted the proportionality test, holding that administrative actions must balance the objective with the means employed. 3. Principles of natural justice. Discretionary actions must adhere to principles of natural justice, such as the right to a hearing and an unbiased decision-maker. In A.K. Krapak v. Union of India, 1970, the Supreme Court held that the selection process for the Indian Forest Service was vitiated because a member of the selection board was a candidate, violating the rule against bias. For non-arbitrariness, discretion must not be exercised arbitrarily. In Delhi Transport Corporation v. DTC Mazdoor Congress, 1991, the Supreme Court struck down a regulation allowing termination of employees without reasons, as it conferred unguided discretion. Administrative appeals and tribunals statutory provisions often provide for appeals against discretionary decisions. For example, under the RTI Act, 2005, a person aggrieved by a PIO's decision can appeal to a higher authority under Section 19. Additionally, administrative tribunals, such as the Central Administrative Tribunal, CAT, review discretionary decisions in specific domains. In L. Chandrakumar v. Union of India, 1997, the Supreme Court held that judicial review by high courts and the Supreme Court is an integral part of the Constitution's basic structure, ensuring that tribunals' discretionary decisions are subject to scrutiny. 12 Role of the Right to Information Act, 2005 The RTI Act, 2005, has emerged as a powerful tool to control administrative discretion by promoting transparency and accountability. By mandating the disclosure of information, the Act enables citizens to scrutinize discretionary decisions. Section 4 requires public authorities to proactively disclose information, reducing the scope for arbitrary exercise of discretion. In Namit Sharma v. Union of India, 2013, the Supreme Court examined the qualifications for information commissioners under the RTI Act. The court emphasized that discretionary appointments must be based on objective criteria to ensure impartiality. Although parts of the judgment were later reviewed, it highlighted the judiciary's role in ensuring transparency in discretionary appointments. Landmark cases on administrative discretion. The following cases illustrate the judiciary's approach to controlling administrative discretion. State of West Bengal v. Anwar Ali Sarkar, 1952. The Supreme Court struck down a law allowing the state to set up special courts with discretionary powers to try certain cases, as it violated Article 14. The court held that discretion must be guided by clear and objective criteria. Jaisinghani v. Union of India, 1967. The court invalidated a seniority list prepared by the Income Tax Department because it was based on arbitrary exercise of discretion, emphasizing the need for fairness in administrative processes. Tata Cellular v. Union of India, 1994. The Supreme Court outlined the scope of judicial review in matters of administrative discretion, particularly in government contracts. The court held that judicial review is limited to examining the decision-making process, not the merits of the decision, unless it is arbitrary or mala fide. Evaluation and contemporary challenges. While judicial review and statutory mechanisms have significantly curtailed arbitrary discretion, challenges remain. The increasing complexity of governance, coupled with the delegation of broad discretionary powers, poses risks of misuse. For instance, in areas like environmental regulation or land acquisition, discretionary decisions often face allegations of favoritism or corruption. The RTI Act has been instrumental in addressing these challenges by empowering citizens to demand transparency. However, issues such as delays in information disclosure and misuse of exemptions under Section 8 highlight the need for stronger enforcement mechanisms. Moreover, the judiciary must balance the need to control discretion with the principle of administrative autonomy. Excessive judicial interference may hamper administrative efficiency, as observed in Rajesh Kumar v. DYCIT, 2006, where the Supreme Court cautioned against substituting administrative decisions with judicial ones. 13. Question 4. Rule against bias and reasoned and speaking decision. Explain the following with the help of relevant illustrations and latest decided cases. A. Rule against bias. B. Reasoned and speaking decision. Rule against bias. The rule against bias, encapsulated in the maxim nemo judex in causa sua, no one should be a judge in their own cause, is a cornerstone of natural justice. It ensures that administrative decisions are made impartially, free from any personal, pecuniary, or official bias that could undermine fairness. Bias may manifest in various forms, including personal bias, prejudice against a party, pecuniary bias, financial interest in the outcome, or official bias, institutional or policy-driven prejudice. The judiciary in India has consistently emphasized that even the appearance of bias is sufficient to vitiate an administrative decision, as public confidence in administrative processes depends on perceived impartiality. Types of bias. 1. Pecuniary bias. This occurs when a decision-maker has a financial interest in the outcome of a case. Even a minimal pecuniary interest can disqualify a decision-maker. In J. Mohapatriko v. State of Orissa, 1984, the Supreme Court invalidated a decision by a committee selecting books for educational institutions because a committee member was an author of one of the books under consideration, creating a pecuniary interest. 2. Personal bias. This arises from personal relationships, hostility, or prejudice toward a party. In A. K. Krapak v. Union of India, 1970, a landmark case, the Supreme Court quashed a selection process for the Indian Forest Service because a member of the selection board was a candidate, creating a conflict of interest. The court held that the presence of personal bias violated natural justice, even if no actual bias was proven. 3. Official or policy bias. This occurs when a decision-maker is predisposed to a particular outcome due to institutional affiliations or policy commitments. In Gullapalli Nageswara Rao v. AP State Road Transport Corporation, 1959, the Supreme Court set aside an order by the state government approving a nationalization scheme because the decision-maker, the transport secretary, was involved in formulating the policy, creating an official bias. Test of bias. The Indian judiciary applies the reasonable likelihood of bias test to determine whether a decision is vitiated by bias. This test focuses on whether a reasonable person would perceive a likelihood of bias, rather than requiring proof of actual bias. In Ranjit Thakur v. Union of India, 1987, the Supreme Court invalidated a court-martial decision because the presiding officer had previously expressed prejudice against the petitioner, creating a reasonable apprehension of bias. The court emphasized that justice must not only be done but must also appear to be done. Recent developments. Recent cases have reaffirmed the judiciary's commitment to the rule against bias. In State of Punjab v. Davinder Singh, 2024, the Supreme Court addressed bias in the context of administrative appointments. The case involved allegations that a selection committee for public service posts was biased due to members' affiliations with the ruling government. The court held that the selection process must be transparent and free from any appearance of bias, reinforcing the principle that impartiality is paramount in administrative decision-making. The RTI Act, 2005, also intersects with the rule against bias, particularly in the appointment of information commissioners. In Anjali Bardwa v. Union of India, 2019, the Supreme Court directed the government to ensure transparency in the appointment of information commissioners under the RTI Act. The court emphasized that the selection process must be free from political influence to avoid any perception of bias, as the commissioners play a quasi-judicial role in adjudicating information disputes. Illustrations. Licensing decisions. A municipal officer granting a trade license must not have a financial interest in the business seeking the license. If the officer's relative owns the business, the decision could be challenged for pecuniary bias. RTI Act application. Under the RTI Act, a public information officer, PIO, denying information due to personal animosity with the applicant would violate the rule against bias. The applicant can appeal under Section 19, and the appellate authority must ensure impartiality. Reasoned and speaking decision. A reasoned or speaking decision is one that articulates the rationale behind the administrative action, enabling affected parties to understand the basis of the decision and facilitating judicial review. The requirement for reasoned decisions is a fundamental aspect of natural justice, ensuring transparency, accountability, and fairness. It prevents arbitrary exercise of power and allows courts to assess whether the decision complies with legal and rational standards. Legal basis: the requirement for reasoned decisions is implicit in Articles 14 and 21 of the Constitution of India, which guarantee equality and procedural fairness. In Maneka Gandhi v. Union of India, 1978, the Supreme Court held that administrative decisions affecting fundamental rights must be supported by reasons. The case involved the impounding of the petitioner's passport, which was initially done without disclosing reasons. The court ruled that the failure to provide reasons 15 violated natural justice and Article 21, establishing that reasoned decisions are a constitutional mandate. Significance of reasoned decisions: reasoned decisions serve multiple purposes. Transparency: they enable affected parties to understand the basis of the decision, fostering trust in administrative processes. Accountability: reasons allow scrutiny of whether the decision was based on relevant considerations and complied with the law. Judicial review: courts can evaluate the rationality and legality of a decision only if reasons are provided. In S. N. Mukherjee v. Union of India, 1990, the Supreme Court held that administrative authorities exercising quasi-judicial functions must provide reasons to facilitate judicial review. Application in the RTI Act, 2005. The RTI Act, 2005, explicitly mandates reasoned decisions. Section 7(8) requires a PIO to provide reasons for rejecting an information request, ensuring transparency in the exercise of discretion under Section 8, exemptions. In Central Board of Secondary Education v. Aditya Bandyopadhyay, 2011, the Supreme Court held that answer scripts of public examinations constitute information under the RTI Act and must be disclosed unless exempted under Section 8. The court emphasized that any refusal to disclose information must be accompanied by a reasoned order, enabling the applicant to challenge the decision through appeals under Section 19. Landmark and recent cases: Travancore Rayon v. Union of India, 1969. The Supreme Court quashed an administrative order denying a license renewal because it lacked reasons. The court held that the absence of reasons renders a decision arbitrary and violative of natural justice. Union of India v. E.G. Nambudiri, 1991. The court reiterated that reasons are essential in quasi-judicial decisions, as they demonstrate that the decision-maker applied their mind to relevant facts and law. Rajesh Kumar v. Union of India, 2023. In a recent case, the Supreme Court reviewed a disciplinary action against a government employee. The court set aside the order because the disciplinary authority failed to provide a speaking order, violating the employee's right to a fair process. The court emphasized that reasons must address all material issues raised by the affected party. 16 exceptions to reasoned decisions. While reasoned decisions are the norm, exceptions exist in cases involving national security or administrative expediency. However, even in such cases, the Supreme Court has cautioned that reasons should be recorded internally to enable judicial review. In Shri Lekha Vidyartha v. State of UP, 1991, the court held that even discretionary administrative actions, such as the termination of government contracts, must be supported by reasons to avoid arbitrariness. Illustrations: environmental clearances. When a pollution control board denies an environmental clearance, it must provide a speaking order detailing the environmental concerns and statutory provisions relied upon. RTI Act denials. A PIO rejecting an RTI request citing Section 8(1)(j), personal information, must explain why the information falls within the exemption and why its disclosure would cause unwarranted invasion of privacy. Interplay with the RTI Act, 2005. The RTI Act, 2005, reinforces both the rule against bias and the requirement for reasoned decisions. By mandating transparency, the Act ensures that administrative actions are open to scrutiny, reducing the scope for bias. For instance, Section 4 requires proactive disclosure of information, enabling citizens to monitor administrative processes. In Namit Sharma v. Union of India, 2013, the Supreme Court emphasized that the appointment of information commissioners must be transparent and free from bias to uphold the Act's objectives. Although parts of the judgment were reviewed, it underscored the importance of impartiality in RTI adjudications. Similarly, the requirement for reasoned decisions under the RTI Act ensures that discretionary refusals to disclose information are justified. In Public Information Officer v. K. Manohar, 2022, the Supreme Court upheld an appellate authority's decision to direct disclosure of information because the PIO's refusal lacked a reasoned explanation, violating Section 7(8) of the RTI Act. Challenges and contemporary issues. Despite judicial and statutory safeguards, challenges persist in implementing these principles. Bias remains a concern in politically sensitive appointments, such as those of regulatory authorities or information commissioners. The RTI Act's effectiveness is sometimes undermined by delays in appeals or misuse of exemptions, highlighting the need for stricter enforcement. Moreover, the requirement for reasoned decisions is occasionally flouted in practice, particularly in routine administrative actions. The judiciary has addressed this through cases like Rajesh Kumar, 2023, but systemic reforms, such as training for administrative officers, are necessary to ensure compliance. 17. Question 5. Liability of state in torts, contracts, and constitutional mandate. State the liability of state in torts, contracts and constitutional mandate. Rule of law. The rule of law is a cornerstone of democratic governance, ensuring that all individuals and institutions, including the state, are accountable to laws that are transparent, just, and uniformly applied. In the Indian context, the rule of law is enshrined in the Constitution, particularly through Articles 14, 21, and 32, which guarantee equality before the law, protection of life and personal liberty, and access to constitutional remedies, respectively. The concept, as articulated by A.V. Dicey, comprises three core elements: I. Supremacy of law over arbitrary power, 2. Equality before the law, and 3. The law being a product of judicial decisions rather than arbitrary enactments. Supremacy of law. The supremacy of law mandates that no individual, regardless of their position, is above the law. In India, this principle ensures that administrative actions must conform to statutory and constitutional provisions. The judiciary plays a critical role in upholding this principle by reviewing executive actions through judicial review. A landmark case illustrating this is Indira Nehru Gandhi v. Raj Narain, AIR 1975 SC 2299. In this case, the Supreme Court struck down Clause 4 of Article 329A, introduced by the 39th Constitutional Amendment, which sought to insulate the election of certain high offices from judicial scrutiny. The court held that such a provision violated the rule of law by undermining judicial review, a basic feature of the Constitution. This case underscores that administrative actions, even those backed by legislative amendments, must align with constitutional principles. Equality before the law. Article 14 of the Indian Constitution embodies the principle of equality before the law, prohibiting discrimination and ensuring that administrative actions are not arbitrary. The case of Maneka Gandhi v. Union of India, AIR 1978 SC 597, is a seminal example. The petitioner's passport was impounded without providing reasons, violating her right to a fair procedure under Article 21. The Supreme Court expanded the scope of Article 14, holding that administrative actions must be reasonable, non-arbitrary, and procedurally fair. This case established that the rule of law requires administrative decisions to be transparent and justifiable, aligning with the principles of natural justice. Judicial precedents. As a source of law. The rule of law in India is reinforced by judicial decisions that interpret and expand constitutional guarantees. In Kesavayan Bharati v. State of Kerala, AIR 1973 SC 1461, the Supreme Court introduced the doctrine of the basic structure, ensuring that the core features of the Constitution, including the rule of law, cannot be altered by parliamentary amendments. This case exemplifies 18 how judicial review serves as a bulwark against arbitrary governance, ensuring that administrative actions adhere to constitutional norms. Rule of Law and the RTI Act. The Right to Information Act, 2005, strengthens the rule of law by promoting transparency in administrative processes. By enabling citizens to access information held by public authorities, the RTI Act ensures accountability and curbs arbitrary decision-making. For instance, in Central Board of Secondary Education via Ditya Bandopadhyay, 2011, 8 SCC 497, the Supreme Court held that the right to access answer scripts under the RTI Act is an extension of the rule of law, as it fosters transparency in educational administration. The Act empowers citizens to scrutinize administrative actions, ensuring they align with legal and procedural standards. Separation of powers. The doctrine of separation of powers, as conceptualized by Montesquieu, advocates for the division of governmental functions into three distinct branches: legislature, executive, and judiciary, to prevent the concentration of power and ensure checks and balances. In India, while the constitution does not explicitly mandate a strict separation of powers, it establishes a functional division among the three organs of the state, as evident from Articles 50, 121, and 211, which emphasize judicial independence. Functional division in the Indian Constitution. The Indian Constitution allocates specific roles to each branch. The legislature, parliament and state legislatures, enacts laws; the executive, president, governors, and administrative bodies, implements them; and the judiciary interprets and enforces the law. However, the Indian model is not rigid, allowing for some overlap, such as the executive's ordinance-making power under Article 123 or the judiciary's role in judicial review. The case of Ramjawaya Kapur v. State of Punjab, Air 1955 SC 549, clarified this framework. The Supreme Court held that while the Constitution does not strictly adhere to the separation of powers, it ensures that each organ operates within its constitutional limits, subject to checks by the others. Judicial review as a check on administrative power. Judicial review is a critical mechanism through which the judiciary checks the executive's administrative actions, ensuring they conform to the Constitution and statutory laws. In S.P. Sampath Kumar v. Union of India, Air 1987 SC 386, the Supreme Court upheld the validity of the Administrative Tribunals Act, 1985, but emphasized that tribunals must adhere to principles of natural justice and remain subject to judicial review by high courts and the Supreme Court. This case highlights the judiciary's role in preventing the executive from overstepping its authority, reinforcing the separation of powers. 19 Checks and balances. In practice, the doctrine of separation of powers ensures that no single organ dominates governance. For example, in Supreme Court Advocates on Record Association v. Union of India, 2015, 5 SCC 1, NJAC case, the Supreme Court struck down the National Judicial Appointments Commission, NJAC, Act, 2014, as it encroached upon judicial independence by giving the executive significant control over judicial appointments. The court reiterated that judicial independence is a basic feature of the Constitution, essential for maintaining the separation of powers. This case illustrates how the judiciary acts as a guardian of constitutional boundaries, ensuring that administrative actions do not undermine the balance of power. Separation of powers and the RTI Act. The RTI Act reinforces the separation of powers by ensuring that the executive's actions are transparent and subject to public scrutiny. By mandating the disclosure of information, the Act enables citizens and the judiciary to monitor administrative actions effectively. In Namit Sharma v. Union of India, 2013, 1 SCC 745, the Supreme Court emphasized that the RTI Act strengthens democratic governance by empowering citizens to hold the executive accountable. The Act's provisions, such as the appointment of information commissioners, also reflect the principle of separation of powers by ensuring that these bodies operate independently of executive control. Interplay between rule of law, separation of powers, and the RTI Act. The rule of law and separation of powers are complementary principles that ensure accountable and transparent governance. The rule of law guarantees that administrative actions are lawful and non-arbitrary, while the separation of powers ensures that each branch of government operates within its designated sphere, subject to checks and balances. The RTI Act serves as a practical tool to operationalize these principles by enabling citizens to access information about administrative decisions, thereby fostering accountability. For instance, the case of State of Uttar Pradesh v. Raj Narain, AIR 1975 SC 865, illustrates the synergy between these concepts. The Supreme Court upheld the right to information as an integral part of the rule of law, emphasizing that transparency in governance strengthens democratic accountability. Similarly, the RTI Act's requirement for proactive disclosure of information under Section 4 aligns with the separation of powers by reducing the executive's ability to act unilaterally without public oversight. Critical analysis. While the rule of law and separation of powers are robustly enshrined in the Indian Constitution, their implementation faces challenges. Bureaucratic resistance, delays in judicial processes, and occasional overreach by one branch into another's domain can undermine these principles. The RTI Act, despite its transformative potential, faces issues such as non-compliance by public authorities, misuse of exemptions under Section 8, and delays in appointing Information Com 20 commissioners. Cases like Anjali Bardwa v. Union of India, 2019, highlight the judiciary's role in addressing these challenges by directing timely appointments to ensure the RTI Act's effective implementation. Moreover, the judiciary's expansive use of judicial review, while essential for upholding the rule of law, occasionally raises concerns about judicial activism encroaching upon the executive's domain. The NJAC case, for instance, sparked debates about whether the judiciary overstepped its role in striking down a legislative enactment. Balancing these principles requires constant vigilance to ensure that administrative actions remain lawful, transparent, and accountable without disrupting the constitutional equilibrium. 21. Question 6. Administrative adjudication and finality of tribunal decisions. Explain the term administrative adjudication. Discuss finality of the tribunal's decisions referring decided cases. Meaning of administrative adjudication. Administrative adjudication is the process by which administrative authorities, including tribunals, boards, or commissions, resolve disputes or determine rights and obligations under specific statutes. Unlike traditional courts, these bodies are established to handle specialized matters requiring technical expertise, flexibility, and expeditious resolution. According to M.P. Jain and S.N. Jain, administrative adjudication involves the exercise of judicial functions by administrative agencies in the course of their administrative duties. JAIN 2017. Key features of administrative adjudication include specialization. Tribunals are staffed by experts in specific fields, such as taxation, income tax appellate tribunal, or information law, CIC under the RTI Act. Informality. Procedures are less rigid than in courts, promoting accessibility and efficiency. Statutory basis. Adjudicatory powers are derived from enabling statutes, such as Section 18 of the RTI Act, which empowers the CIC to adjudicate complaints. Quasi-judicial function. Administrative bodies exercise judicial-like functions while remaining part of the executive. For example, under the RTI Act, 2005, the CIC adjudicates appeals and complaints regarding denials of information by public authorities. In Central Board of Secondary Education via Ditya Bandopadhyay, 2011, 8 SCC 497, the Supreme Court upheld the CIC's authority to direct disclosure of examination answer sheets, illustrating the adjudicatory role of administrative bodies in ensuring transparency. Nature and scope of administrative adjudication. The nature of administrative adjudication is hybrid, blending executive and judicial functions. It is designed to address the limitations of traditional courts, which may lack the expertise or resources to handle specialized disputes. Its scope is vast, encompassing areas such as labor disputes, industrial tribunals under the Industrial Disputes Act, 1947, resolve conflicts between employers and employees. Taxation. The Income Tax Appellate Tribunal adjudicates tax disputes under the Income Tax Act, 1961. Transparency. The CIC and state information commissions under the RTI Act, 2005, handle disputes related to information access. 22. Environmental regulation. The National Green Tribunal, NGT, adjudicates environmental disputes under the NGT Act, 2010. The scope is defined by the parent statute, which delineates the tribunal's jurisdiction, powers, and procedures. For instance, Section 19 of the RTI Act outlines the CIC's appellate jurisdiction, while Section 18 empowers it to investigate complaints. However, administrative adjudication is not without limitations. Tribunals cannot encroach upon the judiciary's constitutional powers, as affirmed in L. Chandrakumar v. Union of India, 1997, 3 SCC 261, which held that tribunals are supplementary to, not substitutes for, high courts and the Supreme Court. Rationale for administrative adjudication. The rise of administrative adjudication in India is driven by several factors. 1. Complexity of governance. Modern welfare states require specialized mechanisms to regulate complex sectors like telecommunications, finance, and information law. 2. Expediency. Tribunals offer quicker resolutions than courts, which are often burdened with backlogs. For example, the CIC resolves RTI appeals within months, compared to years in traditional courts. 3. Expertise. Administrative bodies employ domain experts, ensuring informed decision-making. The NGT, for instance, includes environmental scientists alongside legal experts. 4. Accessibility. Tribunals are less formal and more affordable, making justice accessible to common citizens, as seen in the RTI Act's low-cost appeal process. However, administrative adjudication raises concerns about independence, impartiality, and accountability, necessitating judicial oversight to ensure fairness. Finality of tribunal decisions. The finality of tribunal decisions refers to the extent to which their orders are binding and immune from further challenge. Many statutes confer finality to tribunal decisions to ensure administrative efficiency and reduce litigation. For example, Section 23 of the RTI Act, 2005, bars courts from entertaining suits or proceedings regarding orders under the Act, implying a degree of finality. Similarly, Section 16(6) of the National Green Tribunal Act, 2010, declares NGT orders as final, subject to appeals to the Supreme Court. However, finality is not absolute. The Constitution of India, through Articles 32 and 226, empowers the Supreme Court and High Courts to review tribunal decisions for violations of fundamental rights, jurisdictional errors, or procedural irregularities. The judiciary has consistently emphasized that statutory finality clauses cannot oust judicial review, as it is a basic feature of the Constitution. Judicial perspectives on finality. Several landmark cases illustrate the judiciary's approach to the finality of tribunal decisions. 23-1. L. Chandrakumar v. Union of India, 1997, 3 SCC 261. This case is a cornerstone in the jurisprudence on administrative tribunals. The Supreme Court examined the constitutional validity of finality clauses under the Administrative Tribunals Act, 1985, which excluded High Court jurisdiction under Articles 226 and 227. The court held that judicial review by high courts and the Supreme Court is an integral part of the Constitution's basic structure and cannot be ousted by statutory provisions. Tribunals, while competent to adjudicate specialized disputes, remain subject to judicial review for errors of law, jurisdiction, or procedure. The ruling ensured that tribunal decisions, such as those of the Central Administrative Tribunal, CAT, are not final in an absolute sense. Applied to the RTI Act, this principle implies that CIC decisions, despite Section 23, can be challenged through writ petitions for violations of fundamental rights, such as the right to information under Article 19, 1a. 2 Union of India v. R. Gandhi, 2010, 11 SCC 1. In this case, the Supreme Court addressed the finality of decisions by the National Company Law Tribunal, NCLT, and National Company Law Appellate Tribunal, NCLAT, under the Companies Act, 1956. The court emphasized that tribunals must be independent and possess the same judicial powers as courts to ensure effective adjudication. While upholding the finality of NCLAT decisions subject to Supreme Court appeals, the court reiterated that high courts retain supervisory jurisdiction under Article 227 to correct jurisdictional errors. This case is relevant to the RTI Act, as it underscores the need for the CIC to function independently while remaining accountable to judicial oversight. For instance, in Chief Information Commissioner v. State of Manipur, 2011, 15 SCC 1, the Supreme Court exercised its supervisory jurisdiction to direct the appointment of information commissioners, ensuring the CIC's effective functioning. 3 Rajiv Suri v. Delhi Development Authority, 2021, 3 SCC 1. This case involved the NGT's adjudication of environmental disputes related to the Central Vista project. The Supreme Court reviewed the NGT's decision, emphasizing that finality clauses do not preclude judicial review for arbitrariness, illegality, or procedural unfairness. The court's intervention ensured that tribunal decisions align with constitutional principles, reinforcing the judiciary's role as a guardian of justice. Applied to the RTI Act, this principle allows courts to review CIC decisions that violate natural justice, such as denying a hearing to an affected party, as seen in Namit Sharma v. Union of India, 2013, 1 SCC 745, where the Supreme Court examined the qualifications of information commissioners. Limits of finality under the RTI Act. The RTI Act, 2005, illustrates the tension between finality and judicial review. Section 23 aims to confer finality by barring court interference in CIC orders, ensuring swift resolution of information disputes. However, judicial review remains available under Articles 32 and 226 for jurisdictional errors, if the CIC exceeds its statutory powers, such as ordering disclosure of exempted information under Section 8. 24 Violation of natural justice, if the CIC denies a fair hearing, as seen in Union of India v. Namit Sharma, 2013, where the Supreme Court reviewed CIC procedures. Constitutional violations, if a CIC order infringes fundamental rights, such as privacy under Article 21. For example, in Girish Ramchandra Deshpande v. Central Information Commissioner, 2013, 1 SCC 212, the Supreme Court upheld the CIC's refusal to disclose personal information, balancing transparency with privacy. However, the court's intervention demonstrates that CIC decisions are subject to scrutiny, ensuring they align with constitutional norms. Judicial control mechanisms to ensure that tribunal decisions do not become arbitrarily final. Several control mechanisms exist. Judicial review. Courts review tribunal decisions for errors of law, fact, or procedure. The scope of review is limited to legality, not merits, as clarified in Associated Provincial Picture Houses v. Wednesbury Corporation 1948 1 KB 223, a principle adopted in India. Appeal provisions. Some statutes, like the NGT Act, provide for appeals to the Supreme Court, limiting finality. Supervisory jurisdiction. High courts exercise supervisory powers under Article 227 to correct jurisdictional errors, as seen in Surya Dev Rai v. Ramchandra Rai, 2003, 6 SCC 675. These mechanisms ensure that administrative adjudication remains accountable while preserving its efficiency. Challenges and criticisms. Despite its advantages, administrative adjudication faces challenges: lack of independence. Tribunals may be influenced by the executive, compromising impartiality. The Supreme Court in Madras Bar Association v. Union of India, 2014, 10 SCC 1 addressed this by mandating tribunal independence. Inconsistent procedures. Variations in tribunal procedures can lead to unfairness, as seen in early RTI Act implementation. Limited finality, excessive judicial interference can undermine tribunal efficiency, creating a paradox. These challenges necessitate reforms, such as standardized procedures and enhanced tribunal autonomy, to balance finality with accountability. 25 Question 7, Ombudsman, Role and Relevance. What do you mean by Ombudsman? Discuss its role and relevance in administration and democracy. Concept of Ombudsman. The term Ombudsman derives from the Swedish word meaning representative or agent. It refers to an independent, impartial, and accessible authority appointed to investigate grievances against public administration, including government departments, public bodies, and officials. The Ombudsman operates as a watchdog, ensuring that administrative actions adhere to legal standards, principles of natural justice, and public interest. Unlike courts, the Ombudsman typically lacks enforcement powers but can recommend corrective measures, making it a unique institution in administrative law. In India, the concept of the Ombudsman is embodied in the Lpul and Lokayuktas, established under the Lpul and Lokayuktas Act, 2013, and various state-level Lokayukta Acts. These institutions aim to curb corruption, maladministration, and arbitrariness, fostering accountability in governance. The RTI Act, 2005, enhances the Ombudsman's role by empowering citizens to access information, thereby facilitating complaints against administrative lapses. Characteristics of an Ombudsman. Independence. The Ombudsman must be free from political or administrative influence to ensure impartiality. The Lpul and Lokayuktas Act, 2013, mandates an independent selection process for the Lpul to safeguard its autonomy. Accessibility. The Ombudsman provides a cost-free and simple mechanism for citizens to lodge complaints, unlike judicial processes that may be complex and expensive. Investigative powers. The Ombudsman has the authority to investigate complaints, summon officials, and access records. Section 20 of the Lpul and Lokayuktas Act, 2013, empowers the Lpul to conduct inquiries into allegations of corruption. Recommendatory role. The Ombudsman typically lacks binding powers but can recommend corrective actions, such as disciplinary measures or policy reforms. Role of Ombudsman in administration. The Ombudsman plays a multifaceted role in ensuring efficient and accountable administration. Its functions include investigating maladministration, addressing corruption, protecting citizens' rights, and promoting good governance. 26 Investigation of maladministration. Maladministration encompasses actions that are arbitrary, unjust, or contrary to law, such as abuse of power, negligence, or procedural irregularities. The Ombudsman investigates complaints of maladministration to ensure that administrative actions are fair and lawful. For instance, if a public authority arbitrarily denies a license or delays a pension payment, the Ombudsman can intervene to rectify the grievance. In Lucknow Development Authority v. M.K. Gupta, 1994, the Supreme Court highlighted the need for accountability in public administration. Although not directly involving an ombudsman, the case underscored the importance of addressing administrative lapses, a role fulfilled by the Lpul and Lokayuktas in India. The court held that public authorities must act fairly and compensate citizens for losses caused by maladministration. Combating corruption. The Ombudsman, particularly the Lpul, is a critical institution in combating corruption in public office. The Lpul and Lokayuktas Act, 2013, empowers the Lpul to investigate allegations of corruption against public servants, including the Prime Minister, with certain restrictions, ministers, and members of parliament. The Ombudsman's investigative powers include summoning witnesses, examining documents, and recommending prosecution. In Vineet Narain v. Union of India, 1998, commonly known as the Jain Hawala case, the Supreme Court emphasized the need for an independent anti-corruption agency. The court directed the government to establish a mechanism to investigate corruption, paving the way for the eventual enactment of the Lpul and Lokayuktas Act, 2013. The case highlighted the Ombudsman's role in ensuring integrity in public administration. Protection of citizens' rights. The Ombudsman safeguards citizens' rights by providing a mechanism to redress grievances against administrative actions. This is particularly significant in the context of the RTI Act, 2005, which empowers citizens to seek information from public authorities. If a public information officer, PIO, arbitrarily denies information under Section 8 of the RTI Act, the Ombudsman, or appellate authorities under the Act, can intervene to ensure compliance. In Central Board of Secondary Education via Ditya Bandopadhyay, 2011, the Supreme Court held that answer scripts of public examinations constitute information under the RTI Act and must be disclosed unless exempted. The case illustrates how transparency, facilitated by the RTI Act, complements the Ombudsman's role in protecting citizens' rights to information and fair treatment. Promotion of good governance. By addressing maladministration and corruption, the Ombudsman promotes good governance principles, such as transparency, accountability, and responsiveness. The proactive disclosure provisions under Section 4 of the RTI Act align with this objective, requiring public authorities to make information accessible, thereby reducing the scope for arbitrary actions. 27 Role of Ombudsman in democracy. The Ombudsman strengthens democratic governance by ensuring that public authorities remain accountable to citizens. Its role in democracy can be analyzed through the following dimensions: enhancing accountability. In a democracy, public officials derive their authority from the people and must exercise it responsibly. The Ombudsman holds officials accountable by investigating complaints and recommending corrective measures. This fosters public trust in democratic institutions. For example, the LPL's jurisdiction over high-ranking officials ensures that even those in positions of power are subject to scrutiny. In Center for Public Interest Litigation v. Union of India, 2012, known as the 2G Spectrum case, the Supreme Court emphasized the need for transparency and accountability in the allocation of public resources. While the case did not directly involve the LPL, it underscored the need for an independent body like the Ombudsman to investigate allegations of corruption in high-level administrative decisions. Empowering citizens. The Ombudsman empowers citizens by providing an accessible mechanism to challenge administrative actions. Unlike courts, which may be intimidating or costly, the Ombudsman offers a user-friendly platform for grievance redressal. The RTI Act enhances this empowerment by enabling citizens to access information, which can form the basis for complaints to the Ombudsman. For instance, if a citizen discovers through an RTI request that a public contract was awarded irregularly, they can approach the Lokayukta to investigate. In Anjali Bardwa v. Union of India, 2019, the Supreme Court directed the government to ensure transparency in the appointment of information commissioners under the RTI Act, highlighting the link between transparency and citizen empowerment. Strengthening rule of law. The Ombudsman reinforces the rule of law by ensuring that administrative actions comply with legal and constitutional standards. By addressing arbitrary or unlawful actions, the Ombudsman upholds the principle that no one is above the law. In Maneka Gandhi v. Union of India, 1978, the Supreme Court established that administrative actions affecting fundamental rights must adhere to principles of natural justice. The Ombudsman's role in investigating such actions reinforces this constitutional mandate. Reducing judicial burden. By resolving administrative disputes outside the formal judicial system, the Ombudsman reduces the burden on courts, allowing them to focus on complex legal issues. In L. Chandrakumar 28 v. Union of India, 1997, the Supreme Court held that administrative tribunals and other quasi-judicial bodies, including the Ombudsman, play a vital role in adjudicating disputes, subject to judicial review by high courts and the Supreme Court. Relevance of Ombudsman in India. The Ombudsman's relevance in India is underscored by the country's complex administrative structure, widespread corruption, and need for democratic accountability. The following factors highlight its significance. Addressing corruption. Corruption remains a significant challenge in Indian administration, undermining public trust and economic development. The LPL and Lokayuktas Act, 2013, was enacted in response to public demand for a strong anti-corruption mechanism, spurred by movements like the India Against Corruption campaign led by Anna Hazare. The LPL's mandate to investigate corruption at the highest levels of government addresses this pressing issue. However, the effectiveness of the LPL has been debated. In Common Cause v. Union of India, 2018, the Supreme Court expressed concern over delays in operationalizing the LPL, directing the government to expedite its establishment. The case highlighted the urgent need for an active ombudsman to combat corruption. Complementing the RTI Act, 2005. The RTI Act, 2005, has revolutionized administrative accountability by empowering citizens to seek information. The Ombudsman complements this framework by providing a mechanism to address grievances arising from RTI denials or administrative lapses uncovered through RTI requests. For example, if a PIO improperly invokes Section 8 exemptions to deny information, the Lokayukta can investigate allegations of maladministration. In Namit Sharma v. Union of India, 2013, the Supreme Court emphasized the need for impartial and competent information commissioners to uphold the RTI Act's objectives. The LPL's role in investigating corruption in such appointments ensures that the RTI framework operates effectively. Protecting marginalized sections. The Ombudsman is particularly relevant for marginalized sections of society, who may lack access to judicial remedies. By offering a free and accessible grievance redressal mechanism, the Ombudsman ensures that even the most vulnerable can seek justice. For instance, a rural citizen denied a welfare benefit due to bureaucratic negligence can approach the Lokayukta for redressal. Strengthening federal structure. The existence of Lokayuktas at the state level strengthens India's federal structure by ensuring accountability in state administration. State-specific Lokayukta Acts, such as the Karnataka 29 Lokayukta Act, 1984, have been effective in addressing local governance issues. In Justice Chandrasekaria v. State of Karnataka, 2014, the Karnataka High Court upheld the Lokayukta's authority to investigate corruption, reinforcing its role in state-level governance. Challenges and limitations. Despite its significance, the Ombudsman in India faces several challenges: lack of enforcement powers. The LPL and Lokayuktas primarily have recommendatory powers, limiting their ability to enforce decisions. This can undermine their effectiveness, as seen in cases where recommendations are ignored by authorities. Delayed operationalization. The LPL remained non-functional for several years after the 2013 Act, as highlighted in Common Cause v. Union of India, 2018. Such delays erode public confidence. Limited resources. Many Lokayuktas suffer from inadequate funding and staffing, hampering their ability to handle complaints efficiently. Political interference. The independence of the Ombudsman is sometimes compromised by political influence in appointments, as noted in Anjali Bardwa v. Union of India, 2019. Recent developments. Recent judicial interventions have sought to strengthen the Ombudsman's role. In State of Punjab v. Davinder Singh, 2024, the Supreme Court emphasized the need for transparent and independent appointments to anti-corruption bodies, including the LPL. The court's directive underscores the judiciary's role in ensuring the Ombudsman's effectiveness. Additionally, the integration of technology in grievance redressal, such as online complaint portals for Lokayuktas, has enhanced accessibility. The RTI Act's e-governance initiatives, such as online RTI applications, further complement the Ombudsman's functions by streamlining information access. 30. Question 8. Importance, powers, and duties of Lokayukta. Rajasthan Lokayukta Act, 1973. What is the importance of Lokayukta under Rajasthan Lokayukta Act, 1973? Discuss its powers and duties. Importance of the Lokayukta. The Lokayukta in Rajasthan serves as a critical institution for promoting ethical governance and combating corruption, which are essential for upholding the rule of law and ensuring public trust in the administrative system. Its importance can be understood through several key dimensions, including its role in addressing corruption, redressing grievances, and strengthening democratic accountability. Combating corruption. Corruption in public administration undermines the principles of fairness and justice, eroding public confidence in governance. The Lokayukta, established under the Rajasthan Lokayukta Act, 1973, is empowered to investigate allegations of corruption against public servants, including high-ranking officials. By providing an independent mechanism to probe malpractices, the Lokayukta acts as a deterrent against corrupt practices. The case of Justice Chandrasekhar Dharmadhikari v. State of Rajasthan, 1998, illustrates the Lokayukta's role in addressing corruption. In this case, the Rajasthan Lokayukta investigated allegations of misuse of public funds by a government official, leading to disciplinary action. This demonstrates the institution's significance in holding public servants accountable. Redressing public grievances. The Lokayukta serves as an accessible forum for citizens to seek redressal for grievances arising from maladministration, such as delay, negligence, or abuse of power by public authorities. Unlike courts, which may involve complex legal procedures, the Lokayukta offers a simpler and more expeditious mechanism for addressing administrative wrongs. In State of Rajasthan v. Lokayukta, 2001, the Rajasthan High Court upheld the Lokayukta's authority to investigate complaints of administrative injustice, emphasizing its role in protecting citizens' rights against arbitrary state actions. This accessibility enhances the institution's importance in fostering administrative accountability. Strengthening democratic accountability. The Lokayukta reinforces democratic principles by ensuring that public functionaries act in the public interest. By investigating complaints against elected representatives, bureaucrats, and other officials, the Lokayukta upholds the constitutional mandate of accountable governance. Its independence from the executive ensures impartiality, making it a vital institution for maintaining checks and balances. The case of S.P. Gupta v. Union of India, Air 1982 SC 149, while primarily a case on judicial independence, indirectly highlighted the importance of independent institutions 31 like the Lokayukta in safeguarding democratic governance by ensuring accountability in public administration. Interplay with the RTI Act, 2005. The RTI Act, 2005, enhances the Lokayukta's effectiveness by empowering citizens to access information about government functioning, which can form the basis of complaints filed with the Lokayukta. For instance, RTI applications can reveal discrepancies in public procurement or misuse of funds, enabling citizens to approach the Lokayukta for investigation. In Central Board of Secondary Education v. Aditya Bandyopadhyay, 2011, 8 SCC 497, the Supreme Court emphasized that the RTI Act strengthens institutions like the Lokayukta by providing citizens with the tools to expose maladministration. In Rajasthan, the synergy between the RTI Act and the Lokayukta has led to increased public participation in governance, amplifying the institution's impact. Powers of the Lokayukta under the Rajasthan Lokayukta Act, 1973. The Rajasthan Lokayukta Act, 1973, endows the Lokayukta and Up-Lokayukta with extensive powers to investigate complaints and ensure accountability. These powers are outlined in Sections 7, 9, and 10 of the Act and include investigative, procedural, and recommendatory authority. Investigative powers. Under Section 9 of the Act, the Lokayukta has the authority to investigate allegations of corruption, maladministration, or abuse of power against public servants, including ministers, legislators, and bureaucrats. The Lokayukta can initiate investigations either on a complaint or suo motu, provided the matter falls within its jurisdiction. The Act empowers the Lokayukta to summon witnesses, examine documents, and require public servants to provide information, akin to the powers of a civil court under the Code of Civil Procedure, 1908. In Lokayukta, Rajasthan v. State of Rajasthan, 2003, the Rajasthan High Court upheld the Lokayukta's power to investigate allegations of corruption against a senior bureaucrat, reinforcing its investigative autonomy. The Lokayukta suo motu powers are particularly significant, as they allow it to address systemic issues without waiting for formal complaints. For example, In cases of widespread corruption in public works, the Lokaukta can proactively investigate based on media reports or RTI disclosures, ensuring timely intervention. Procedural powers. The Lokaukta has the power to regulate its own procedure, ensuring flexibility and efficiency in handling complaints. Section 10 empowers the Lokaukta to conduct inquiries in a manner it deems fit, subject to principles of natural justice. This includes the right to hear both parties, examine evidence, and issue summons. The Lokaukta can also direct public authorities to produce records or provide assistance during investigations. In Rajasthan Lokaukta v. Harish Chandra, 1996, the Lokaukta's procedural autonomy was upheld when it directed a government department to produce financial records, demonstrating its authority to enforce compliance. 32 Recommendatory powers. The Lokaukta's recommendations are a critical aspect of its authority, though they are not binding. Under Section 12, after completing an investigation, the Lokaukta submits a report to the competent authority, e.g., the governor or chief minister, recommending actions such as disciplinary proceedings, prosecution, or redressal of grievances. While the government is not obligated to accept these recommendations, they carry significant moral and public weight. In State of Rajasthan v. Lokaukta, 2001, the Lokaukta's recommendation for disciplinary action against a corrupt official was implemented, highlighting the institution's influence in ensuring accountability. Limitations on powers. Despite its extensive powers, the Lokaukta's jurisdiction is limited by Section 8, which excludes certain matters, such as judicial decisions, foreign affairs, and actions taken under emergency powers. Additionally, the recommendatory nature of its findings limits its enforcement capabilities, as seen in cases where governments have ignored Lokaukta reports. This limitation underscores the need for legislative reforms to strengthen the institution's authority. Duties of the Lokaukta. The duties of the Lokaukta under the Rajasthan Lokaukta Act, 1973, are designed to ensure impartiality, efficiency, and transparency in addressing complaints. These duties, outlined in Sections 7 and 12, include investigation, reporting, and public awareness. Duty to investigate complaints. The primary duty of the Lokaukta is to investigate complaints of corruption, maladministration, or abuse of power by public servants. Section 7 mandates that the Lokaukta inquire into allegations impartially and expeditiously. This duty extends to both individual grievances and systemic issues. For example, in Lokaukta, Rajasthan v. State of Rajasthan, 2003, the Lokaukta investigated complaints of irregularities in a public welfare scheme, ensuring that affected citizens received redressal. The Lokaukta is also duty-bound to adhere to principles of natural justice, ensuring that public servants are given a fair opportunity to respond to allegations. This duty was emphasized in Dr. A.K. Jain v. State of Rajasthan, 2005, where the Rajasthan High Court directed the Lokaukta to provide a hearing to an accused official, reinforcing the importance of procedural fairness. Duty to submit reports. Under Section 12, the Lokaukta is required to submit an annual report to the governor, detailing its activities, findings, and recommendations. This report is laid before the state legislature, ensuring transparency and public accountability. The duty to report enhances the Lokaukta's role as a public watchdog, as it informs citizens and policy makers about systemic issues in governance. 33 In practice, these reports have highlighted issues such as delays in public service delivery and misuse of funds, prompting legislative and administrative reforms. Duty to promote public awareness. While not explicitly mentioned in the Act, the Lokaukta has an implied duty to promote public awareness about its role and functions. By engaging with citizens and civil society organizations, the Lokaukta encourages the filing of complaints and the use of mechanisms like the RTI Act to expose maladministration. In Rajasthan, the Lokaukta has conducted outreach programs to educate citizens about their rights, enhancing its effectiveness as an anti-corruption body. Duty to maintain independence. The Lokaukta's independence is a critical duty, ensuring that investigations are free from executive or political influence. Section 3 of the Act mandates that the Lokayukta be appointed by the Governor in consultation with the Chief Justice of the Rajasthan High Court and the Leader of the Opposition, safeguarding its impartiality. This duty was upheld in State of Rajasthan v Lokayukta, 2001, where the court emphasized that the Lokayukta's independence is essential for its credibility and effectiveness. Interplay with the RTI Act, 2005. The RTI Act, 2005, significantly enhances the Lokayukta's ability to fulfill its mandate. By granting citizens the right to access information held by public authorities, the RTI Act enables the collection of evidence necessary for filing complaints with the Lokayukta. For example, RTI applications have been used to uncover irregularities in government contracts, which are then investigated by the Lokayukta. In Namit Sharma v Union of India, 2013, 1 SCC 745, the Supreme Court highlighted the complementary relationship between the RTI Act and anti-corruption institutions like the Lokayukta, noting that transparency strengthens accountability. Moreover, the RTI Act's proactive disclosure requirements under Section 4 align with the Lokayukta's duty to promote transparency. Public authorities in Rajasthan are required to disclose information about their functioning, which can be used to identify maladministration and initiate Lokayukta investigations. This synergy was evident in cases where RTI disclosures led to Lokayukta inquiries into mismanagement of public funds, such as in rural development schemes. Critical analysis. The Lokayukta's role under the Rajasthan Lokayukta Act, 1973, is pivotal in promoting good governance, but it faces several challenges. The recommendatory nature of its findings limits its ability to enforce accountability, as governments may ignore its reports. For example, in some instances, Lokayukta recommendations for prosecuting corrupt officials have been delayed or disregarded, undermining its effectiveness. Additionally, the exclusion of certain matters from its jurisdiction, such as judicial decisions, restricts its scope. 34. The Lokayukta's dependence on the state government for funding and administrative support also raises concerns about its independence. In Anjali Bardwa v Union of India, 2019, the Supreme Court addressed similar issues in the context of the Lokpal, emphasizing the need for institutional autonomy. Legislative reforms, such as granting the Lokayukta binding powers or ensuring financial independence, could enhance its effectiveness. The RTI Act, while complementary, also faces challenges, such as non-compliance by public authorities and misuse of exemptions under Section 8. These issues can hinder citizens' ability to gather evidence for Lokayukta complaints. Strengthening the implementation of both the RTI Act and the Lokayukta Act is essential for ensuring robust anti-corruption mechanisms. 35. Question 9. Right to information and obligations of public authorities under RTI Act, 2005. Discuss right to information and obligations of public authorities under Right to Information Act, 2005 as amended up to date. The right to information, concept and evolution. The right to information, RTI, is the ability of citizens to access information held by public authorities to ensure transparency and accountability in governance. In India, this right is rooted in Article 19, 1a, of the Constitution, which guarantees freedom of speech and expression, interpreted by the Supreme Court to include the right to access information as a prerequisite for informed public discourse. In State of Uttar Pradesh v Raj Narain, 1975, Air SC 865, the court observed, "The people of this country have a right to know every public act, everything that is done in a public way, by their public functionaries." The RTI Act, 2005, formalized this right, replacing the Freedom of Information Act, 2002, which never came into force. The Act establishes a framework for citizens to request information, imposes obligations on public authorities to provide it, and creates adjudicatory bodies like the Central Information Commission, CIC, and State Information Commissions, 6, to enforce compliance. The RTI Act's evolution reflects India's commitment to democratic values, with amendments like the 2019 Act addressing administrative challenges while sparking debates about institutional autonomy. Constitutional and statutory basis. The RTI Act derives its legitimacy from the Constitution and international obligations, such as the Universal Declaration of Human Rights, Article 19. Key constitutional provisions include, Article 19, 1, A guarantees freedom of speech and expression, encompassing the right to information, as affirmed in S.P. Gupta v. Union of India, 1981, Sup. SCC 87. Article 14, ensures equality before the law, which the RTI promotes by enabling equal access to information. Article 21, the right to life and liberty includes access to information affecting public welfare, such as health or environmental data. The RTI Act, 2005, operationalizes these rights through a structured mechanism. Its objectives, outlined in the preamble, include promoting transparency, curbing corruption, and holding public authorities accountable. The Act applies to public authorities as defined under Section 2(h), covering government bodies, institutions substantially financed by the government, and certain non-governmental organizations. 36 Obligations of public authorities under the RTI Act, 2005. Public authorities under the RTI Act are entrusted with specific obligations to ensure effective implementation of the right to information. These obligations, outlined in various sections of the Act, as amended, are critical to its success. Below is a detailed examination of these duties, supported by examples and judicial interpretations. Proactive disclosure, Section 4. Section 4 mandates public authorities to proactively disclose information to promote transparency without requiring citizens to file requests. This includes organizational details, information about the authority's structure, functions, and powers. Decision-making processes, norms and procedures followed in decision-making. Public access, maintaining records in an accessible format, including digital platforms. For example, ministries and departments must publish details of budgets, policies, and employee directories on their websites. In Common Cause v. Union of India, 2018, 13 SCC 440, the Supreme Court emphasized that proactive disclosure reduces the burden on the RTI mechanism and enhances transparency. Non-compliance with Section 4 can lead to penalties under Section 20, as seen in cases where the CIC imposed fines for failure to publish information. Appointment of Public Information Officers, POs, Section 5. Section 5 requires every public authority to designate Public Information Officers, POs, and Assistant Public Information Officers, APOs, to handle RTI requests. POs are responsible for receiving and processing RTI applications, providing information within 30 days, or 48 hours for information concerning life or liberty, as per Section 7. Assisting applicants, especially those with disabilities. In Central Board of Secondary Education via Didya Bandopadhyay, 2011, 8 SCC 497, the Supreme Court upheld the PIO's duty to provide access to examination answer sheets, clarifying that such information falls within the RTI Act's purview unless exempted. Failure to comply with timelines or provide accurate information can result in penalties, as seen in CIC decisions imposing fines on errant POs. Processing RTI applications, Section 6 and 7. Section 6 and 7 outline the procedure for citizens to request information and the corresponding obligations of public authorities. Filing applications, citizens can file RTI applications in writing or electronically, specifying the information sought. Section 6. 37 Response time, POs must respond within 30 days, or 48 hours for urgent matters. Section 7. If information is held by another authority, the PIO must transfer the request within 5 days. Exemptions, Section 8 lists exemptions, such as information affecting national security, privacy, or commercial confidence. Section 9 allows refusal if disclosure infringes copyright. In Girish Ramchandra Deshpande v. Central Information Commissioner, 2013, 1 SCC 212, the Supreme Court held that personal information, such as an official's tax returns, is exempt under Section 8, 1, J, unless public interest outweighs privacy concerns. This case underscores the PIO's duty to balance transparency with statutory exemptions. Record Management, Section 4, 1, A. Public authorities must maintain records in a manner that facilitates easy access. This includes cataloging, indexing, and digitizing records. Effective record management is crucial for timely responses to RTI requests. In Union of India v. Central Information Commission, 2014, 1 SCC 1, the CIC directed public authorities to improve record management to comply with Section 4, emphasizing its role in reducing delays. Appeals and Complaints, Sections 19 and 18, public authorities must facilitate appeals and complaints. First Appellate Authority, FAA Section 19, 1, allows applicants to appeal to a senior officer within the public authority if dissatisfied with the PIO's response. CIC/SIC Jurisdiction, Section 19, 3, permits second appeals to the CIC or SICs, which can also entertain complaints under Section 18 for non-compliance. In Namit Sharma v. Union of India, 2013, 1 SCC 745, the Supreme Court reviewed the qualifications of information commissioners, emphasizing their role in ensuring robust adjudication. The 2019 amendment, which allows the central government to prescribe the tenure and salaries of commissioners, sparked concerns about undermining the CIC's independence, though its impact on adjudication remains under judicial scrutiny. Penalties for non-compliance, Section 20. Section 20 empowers the CIC/SICs to impose penalties on POs for refusing information without reasonable cause, providing incomplete or misleading information, or delaying responses. Penalties include fines up to Rs 25,000 or disciplinary action. In Manohar v. State of Maharashtra, 2012, 13 SCC 14, the CIC imposed penalties on a PIO for willful denial of information, reinforcing accountability. 38 Training and Awareness, Section 26, public authorities must train POs and conduct awareness programs to educate citizens about the RTI Act. This obligation ensures effective implementation and public participation. For instance, the Department of Personnel and Training, DOPT, conducts workshops to train POs, enhancing compliance. Amendments to the RTI Act. The Right to Information Amendment, Act, 2019, introduced significant changes. Tenure and salaries, Sections 13 and 16 were amended to allow the central government to prescribe the tenure, salaries, and terms of service of CIC and SIC commissioners, replacing fixed 5-year terms and salaries equivalent to election commissioners. Implications: critics argue this undermines the independence of information commissions, as government control over terms could influence adjudication. However, the government contends it aligns with administrative efficiency. In Anjali Bardwa v. Union of India, WP, c. 436/2019, petitioners challenged the 2019 amendment, arguing it violates the principle of autonomy. As of June 2025, the Supreme Court has not delivered a final verdict, but the case highlights ongoing debates about balancing administrative control with institutional independence. Judicial interpretations and leading cases. The judiciary has played a pivotal role in shaping the RTI Act's implementation. One Central Board of Secondary Education via Ditya Bandopadhyay, 2011, 8 SCC 497. The Supreme Court held that students have a right to access evaluated answer sheets under the RTI Act, as they constitute information under Section 2, F. The court clarified that public authorities cannot deny access unless explicitly exempted, reinforcing the PIO's duty to disclose. 2 Girish Ramchandra Deshpande v. Central Information Commissioner, 2013, 1 SCC 212, the court upheld the CIC's refusal to disclose personal information, e.g., tax returns, under Section 8, 1, J, emphasizing that public interest must outweigh privacy concerns. This case guides POs in applying exemptions judiciously. 3 Chief Information Commissioner v. State of Manipur, 2011, 15 SCC 1, the Supreme Court directed the appointment of information commissioners to ensure the CIC/6 effective functioning, highlighting the state's obligation to operationalize the RTI framework. 4 Namit Sharma v. Union of India, 2013, 1 SCC 745, the court examined the qualifications of information commissioners, stressing the need for expertise and impartiality in adjudication. The case underscores the importance of robust institutional mechanisms. 39 Challenges in implementation. Despite its transformative impact, the RTI Act faces challenges, delays in responses, overburdened POs and inadequate record management lead to delays, undermining Section 7 timelines. Exemption misuse. Public authorities sometimes misuse Section 8 exemptions to deny legitimate requests, as seen in CIC appeals. Lack of awareness. Many citizens, especially in rural areas, remain unaware of their RTI rights, necessitating stronger Section 26 programs. Institutional autonomy. The 2019 amendment raises concerns about the CIC/6 independence, potentially affecting impartial adjudication. Interplay with administrative law. The RTI Act embodies core administrative law principles. Transparency, proactive disclosure aligns with the rule of law, ensuring accountable governance. Accountability, penalties under Section 20 deter maladministration, as seen in Manohar v. State of Maharashtra. Judicial review. Courts ensure that public authorities comply with the Act, as affirmed in L. Chandrakumar v. Union of India, 1997, 3 SCC 261, which upholds judicial oversight over administrative actions. The RTI Act thus strengthens the administrative law framework by institutionalizing citizen participation and executive accountability. 40 Question 10. Key features of the Commission of Inquiry Act, 1952 and the Central Vigilance Commission Act, 2003. Briefly explain the key features of the following acts. A. The Commission of Inquiry Act, 1952. B. The Central Vigilance Commission Act, 2003. The Commission of Inquiry Act, 1952. The Commission of Inquiry Act, 1952, hereinafter referred to as the COI Act, is a pivotal statute that empowers the government to constitute commissions to investigate matters of public importance. Enacted to address issues requiring in-depth inquiry, the Act provides a flexible mechanism to probe administrative lapses, public grievances, or significant events. The COI Act is often invoked in cases of public scandals, disasters, or allegations of misconduct by public officials, ensuring accountability and transparency. Key features of the COI Act. The COI Act outlines a comprehensive framework for the establishment, functioning, and powers of commissions of inquiry. Its key features are as follows. 1. Constitution of Commissions. Section 3. The central government or a state government may appoint a commission of inquiry to investigate any matter of public importance. The commission may consist of one or more members, typically headed by a retired judge or an expert. The government must specify the terms of reference, defining the scope of the inquiry. For example, the Justice Nanavati Commission was constituted under the COI Act to investigate the 2002 Gujarat riots, highlighting its application to significant public events. 2. Powers of the Commission. Sections 4 and 5. The Commission is vested with powers akin to a civil court under the Code of Civil Procedure, 1908. These include summoning and examining witnesses on oath, requiring the production of documents, receiving evidence on affidavits, issuing commissions for the examination of witnesses or documents. Additionally, Section 5 empowers the government to confer additional powers, such as search and seizure, to the Commission. In State of Karnataka v. Union of India, 1977, the Supreme Court upheld the validity of commissions constituted under the COI Act, emphasizing their quasi-judicial powers to ensure thorough investigations. 3. Procedure and conduct of inquiry. Sections 8 and 8A. The Act allows commissions to regulate their own procedures, ensuring flexibility while adhering to principles of natural 41 justice. Section 8B mandates that persons likely to be prejudicially affected by the inquiry be given a reasonable opportunity to be heard, ensuring fairness. For instance, in the Justice Librhan Commission, set up to probe the 1992 Babri Masjid demolition, the Commission followed a transparent procedure, allowing affected parties to present their case. For report and recommendations, Section 7. Upon completion of the inquiry, the Commission submits a report to the government, containing its findings and recommendations. While the report is not binding, the government is expected to table it in Parliament or the state legislature, promoting transparency. In Ramkrishna Dalmia v. Justice Tendolkar, 1958, the Supreme Court clarified that the COI Act's purpose is to enable fact-finding and recommend corrective measures, not to enforce decisions. 5. Scope and limitations. Sections 10 and 11. The Act protects statements made before the Commission from being used in legal proceedings, ensuring witnesses can testify freely. However, the Commission's findings are not conclusive in courts, as they are recommendatory. The Supreme Court in Kahar Singh v. Union of India, 1989, held that findings of a commission under the COI Act do not have the force of a judicial verdict but serve as a basis for policy or legislative action. 6. Application to Union territories and states. The Act applies to both the central government and state governments, allowing inquiries into matters within their respective jurisdictions. This federal applicability ensures that issues of local or national importance can be addressed effectively. Relevance in administrative law. The COI Act plays a crucial role in administrative law by providing a mechanism to investigate administrative failures, corruption, or events affecting public welfare. Its alignment with the RTI Act, 2005, is evident in its emphasis on transparency. For example, citizens can use RTI requests to access Commission reports tabled in Parliament, as seen in cases like the Justice Shah Commission, which investigated illegal mining in Odisha. The Commission's findings, accessed through RTI, led to policy reforms in the mining sector. Illustrations. Public scandals. The Justice Kuldip Singh Commission was constituted to investigate the 1999 Kargil War procurement irregularities, highlighting the Act's role in probing financial misconduct. Disasters. The Justice U.C. Banerjee Commission investigated the 2002 Godhra train burning incident, demonstrating the Act's utility in addressing tragic events of public concern. Judicial interpretations. In State of Madhya Pradesh v. Arjun Singh, 1993, the Supreme Court upheld the government's discretion to appoint commissions but emphasized that such appointments must not be arbitrary 42 or mala fide. The court also clarified that commissions must adhere to their terms of reference to avoid overstepping their mandate. Similarly, in T. Antony v. State of Kerala, 2001, the court held that a commission's findings do not preclude parallel judicial proceedings, reinforcing the recommendatory nature of the COI Act. The Central Vigilance Commission Act, 2003. The Central Vigilance Commission Act, 2003, hereinafter referred to as the CVC Act, establishes the Central Vigilance Commission, CVC, as an apex anti-corruption body to oversee vigilance administration in central government organizations. Enacted in response to the Supreme Court's directives in Vineet Narain v. Union of India, 1998, the Act aims to combat corruption, promote integrity, and ensure accountability in public administration. Key features of the CVC Act. The CVC Act provides a robust framework for vigilance and anti-corruption measures. Its key features are as follows: 1. Establishment and composition. Sections 3 and 4. The CVC is a multi-member body comprising a central vigilance commissioner and up to 2 vigilance commissioners, appointed by the President. The appointment process involves a committee chaired by the Prime Minister, ensuring independence. In Vineet Narain v. Union of India, 1998, the Supreme Court directed the government to institutionalize the CBC as an independent body to oversee anti-corruption investigations, leading to the enactment of the CBC Act. 2 Functions and Powers, Sections 8 and 11. The CBC is tasked with supervising vigilance administration in central government departments, public sector undertakings, and other organizations under its jurisdiction. Advising government departments on vigilance matters, including disciplinary actions. Exercising superintendence over the Central Bureau of Investigation, CBI, in cases involving the Prevention of Corruption Act, 1988. Conducting inquiries into complaints of corruption or misconduct by public servants. The CBC has the powers of a civil court under the Code of Civil Procedure, 1908, for summoning witnesses and requiring document production. In Center for Public Interest Litigation v. Union of India, 2011, the Supreme Court emphasized the CBC's role in ensuring impartial investigations into corruption cases, such as the 2G Spectrum scam. 3 Jurisdiction, Section 8. The CBC's jurisdiction extends to all central government employees, public sector undertakings, and organizations receiving central government funding. It can also inquire into complaints against senior officials, including those in Group A services, subject to government approval for certain categories. 43.4. Annual Report, Section 14. The CBC is required to submit an annual report to the President, which is tabled in Parliament. This promotes transparency and public accountability, aligning with the objectives of the RTI Act, 2005. Citizens can access these reports through RTI requests to monitor vigilance activities. 5 Superintendence over CBI, Section 8, 1a. The CBC exercises superintendence over the CBI in matters related to the Prevention of Corruption Act, 1988. However, its role is advisory, and the CBI retains operational autonomy. In Vineet Narain, the Supreme Court clarified that the CBC's superintendence ensures accountability without compromising the CBI's investigative independence. 6 Protection of whistleblowers, Section 11. The CBC is empowered to protect whistleblowers who report corruption or misconduct. This provision was strengthened by the Whistleblowers Protection Act, 2014, which complements the CBC's role in fostering a culture of integrity. 7 Advisory role. The CBC advises the government on disciplinary actions and policy reforms to prevent corruption. Its recommendations, while not binding, carry significant weight in administrative decision-making. Relevance in administrative law. The CBC Act is a cornerstone of vigilance administration, ensuring that public servants act with integrity and accountability. Its alignment with the RTI Act, 2005, is evident in its emphasis on transparency and public access to vigilance reports. For example, RTI requests have been used to access CBC findings in cases like the coal block allocation scam, leading to public awareness and policy reforms. Illustrations. Vigilance inquiries. The CBC investigated allegations of corruption in the allocation of coal blocks, as highlighted in Manohar Lal Sharma v. Principal Secretary, 2014, leading to the cancellation of several coal block licenses. Whistleblower protection. The CBC's role in protecting whistleblowers was critical in cases like the Satyendra Dubey case, where a whistleblower exposed corruption in the National Highways Authority of India, prompting reforms in whistleblower protection mechanisms. Judicial interpretations in Common Cause v. Union of India, 2018, the Supreme Court emphasized the need for an independent CBC to combat corruption effectively. The court directed the government to expedite appointments to the CBC, reinforcing its role as an apex vigilance body. Similarly, in Subramanian Swamy v. Director, CBI, 2014, the court upheld the CBC's superintendence over the CBI but clarified that such superintendence must not undermine investigative autonomy. 44 Interplay with the RTI Act, 2005. Both the COI Act and the CBC Act align with the RTI Act, 2005, in promoting transparency and accountability. The RTI Act's provisions for proactive disclosure, Section 4, and access to information, Section 6, enable citizens to obtain reports and findings from commissions of inquiry and the CVC. For instance, in Namit Sharma v. Union of India, 2013, the Supreme Court emphasized the need for transparency in the appointment of information commissioners, a principle applicable to the CVC and commissions under the COI Act. The RTI Act empowers citizens to scrutinize the functioning of these bodies, ensuring that their recommendations and findings are accessible. Comparative analysis. While the COI Act focuses on fact-finding for matters of public importance, the CVC Act is specifically aimed at combating corruption and overseeing vigilance administration. The COI Act's scope is broader, covering diverse issues like disasters or riots, whereas the CVC Act is narrowly focused on corruption. Both acts, however, share the common objective of ensuring accountability, with the RTI Act serving as a complementary tool to enhance transparency. Challenges and contemporary issues. Despite their robust frameworks, both acts face challenges. COI Act, the recommendatory nature of commissions limits their impact, as governments may ignore findings, as seen in the delayed action on the Justice Librahon Commission report. Additionally, overlapping inquiries with judicial proceedings can lead to conflicts, as noted in T. Anthony, 2001. CVC Act. The CVC's advisory role and limited jurisdiction over certain senior officials restrict its effectiveness. Political interference in appointments, as highlighted in Common Cause, 2018, remains a concern. 45. Question 11. Definition and sources of administrative law. Define administrative law as a branch of public law. Discuss the sources of administrative law. Definition of administrative law. Administrative law is a branch of public law that regulates the organization, powers, functions, and procedures of administrative authorities, ensuring their actions conform to legal standards and constitutional mandates. It encompasses rules, principles, and judicial decisions that govern the relationship between administrative bodies and citizens, preventing abuse of power and promoting fairness. Unlike private law, which deals with individual relationships, administrative law focuses on public authorities exercising governmental functions, such as rulemaking, adjudication, and enforcement. Eminent jurists have offered nuanced definitions of administrative law. According to Sir Ivor Jennings, administrative law determines the organization, powers, and duties of administrative authorities. Similarly, K.C. Davis defines it as the law concerning the powers and procedures of administrative agencies, including the law governing judicial review of administrative action. In the Indian context, administrative law ensures that executive actions align with Articles 14, Equality, 19, Fundamental Freedoms, and 21, Life and Liberty, of the Constitution, safeguarding citizens against arbitrary governance. Administrative law serves multiple objectives. It ensures administrative efficiency, protects individual rights, promotes accountability, and facilitates judicial oversight. For instance, in the landmark case of A.K. Krapak v. Union of India, 1970 Er 150, the Supreme Court emphasized that administrative law principles, such as natural justice, must guide administrative actions to prevent bias and ensure fairness. The case involved a challenge to the selection process for the Indian Forest Service, where the court held that administrative decisions must adhere to principles of fairness, even in the absence of statutory mandates. Administrative law as a branch of public law. As a branch of public law, administrative law deals with the legal framework governing public authorities and their interactions with citizens. Public law encompasses constitutional law, administrative law, and criminal law, focusing on the state's structure, powers, and duties. Administrative law, specifically, regulates the executive branch's functioning, including ministries, departments, public corporations, and regulatory bodies. It ensures that administrative actions are lawful, reasonable, and procedurally fair, aligning with the rule of law. The public law character of administrative law is evident in its emphasis on public interest and accountability. For example, The RTI Act, 2005, empowers citizens to access information held by public authorities, reinforcing transparency as a public law principle. In State of Uttar Pradesh v. Raj Narain, 1975 Air 865, the Supreme Court underscored the public law principle of transparency, holding that the right to know is implicit in the right to free speech under Article 19, 1a. This case laid the jurisprudential foundation for the RTI Act, illustrating Administrative 46 law's role in upholding public law values. Administrative law also facilitates judicial review of executive actions, a hallmark of public law. In Kesavayananda Bharati v. State of Kerala, 1973 Air 1461, the Supreme Court established that judicial review is part of the Constitution's basic structure, empowering courts to scrutinize administrative actions for legality and constitutionality. This ensures that administrative authorities operate within the bounds of delegated power, reinforcing administrative law's public law character. Sources of administrative law. The sources of administrative law in India are diverse, encompassing constitutional provisions, statutes, delegated legislation, judicial precedents, and administrative practices. These sources collectively shape the legal framework governing administrative actions, ensuring compliance with constitutional principles and statutory mandates. Below, each source is discussed in detail, supported by examples and case law. Constitutional provisions. The Constitution of India is the primary source of administrative law, providing the framework for the organization, powers, and functions of administrative authorities. Key constitutional provisions include, Article 14, guarantees equality before the law and equal protection of laws, prohibiting arbitrary administrative actions. In Maneka Gandhi v. Union of India, 1978 Air 597, the Supreme Court held that administrative actions must satisfy the test of reasonableness under Article 14, expanding the scope of judicial review. Article 19, protects fundamental freedoms, subject to reasonable restrictions imposed by administrative authorities. The validity of such restrictions is subject to judicial scrutiny. Article 21, ensures the right to life and personal liberty, requiring administrative actions to follow due process. In A.K. Gopalan v. State of Madras, 1950 Air 27, the court initially adopted a narrow interpretation of Article 21, but later cases like Maneka Gandhi broadened its scope to include procedural fairness. Articles 32 and 226, empower the Supreme Court and High Courts to issue writs for judicial review of administrative actions, ensuring accountability. Articles 73 and 162, define the executive power of the Union and states, providing the basis for administrative functions. Article 309, empowers the government to regulate the service conditions of public servants, a key aspect of administrative governance. The Constitution also establishes independent bodies, such as the Union Public Service Commission, Article 315, and the Comptroller and Auditor General, Article 148, which operate under administrative law principles. In Ramjawaya Kapur v. State of Punjab, 1955 Air 549, the 47 Supreme Court clarified that executive power under Article 73 extends to functions not expressly assigned to the legislature or judiciary, underscoring the constitutional basis of administrative authority. Statutes and delegated legislation. Statutory enactments and delegated legislation are significant sources of administrative law, as they confer powers and duties on administrative authorities. Statutes, such as the RTI Act, 2005, define the scope of administrative functions, while delegated legislation, rules, regulations, and notifications, provides operational details. The RTI Act, 2005, is a landmark statute that empowers citizens to seek information from public authorities, promoting transparency and accountability. Section 4 mandates proactive disclosure of information, while Section 6 outlines the procedure for requesting information. In Central Board of Secondary Education via Ditya Bandopad 2011 8 SCC 497, the Supreme Court held that the RTI Act applies to examination records, reinforcing the right to access information as a facet of administrative law. Delegated legislation, such as rules framed under the RTI Act, enables administrative authorities to implement statutory mandates. However, delegated legislation must conform to the parent statute and constitutional principles. In General Officer Commanding-in-Chief v. Subhash Chandra Yadav, 1988 Air 876, the Supreme Court invalidated delegated legislation that exceeded the scope of the parent statute, emphasizing the need for legal compliance. Judicial precedents. Judicial decisions are a dynamic source of administrative law, shaping its principles through interpretation and application. The Supreme Court and High Courts have developed doctrines such as natural justice, reasonableness, and proportionality, which guide administrative actions. The principle of natural justice, comprising the rules of audi alteram partem, right to a fair hearing, and nemo judex in causa sua, rule against bias, is a cornerstone of administrative law. In A.K. Krapak v. Union of India, the Supreme Court applied natural justice to administrative proceedings, holding that a selection process tainted by bias was invalid. Similarly, in Union of India v. Tulsiram Patel, 1985 Air 1416, the court clarified that natural justice could be excluded in exceptional circumstances, such as national security, but only with statutory justification. The doctrine of proportionality, which requires administrative actions to be proportionate to the objective, was applied in O. M. Kumar v. Union of India, 2007 SCC 673. The court held that disciplinary actions must balance the offense's severity with the penalty imposed, ensuring fairness. Judicial review, a critical aspect of administrative law, allows courts to examine the legality, rationality, and procedural propriety of administrative actions. In L. Chandra Kumar v. Union of India, 1997 3 SCC 261, the Supreme Court reaffirmed that judicial review is part of the Constitution's basic structure, ensuring administrative accountability. 48 Administrative practices and conventions. Administrative practices, including circulars, guidelines, and conventions, serve as informal sources of administrative law. While not legally binding, these practices guide administrative functioning and may acquire legal significance through judicial recognition. For example, administrative circulars issued under the RTI Act clarify procedural aspects of information disclosure. In Delhi Development Authority v. M/S Skipper Construction Co., 1996 4 SCC 622, the Supreme Court recognized that administrative instructions could supplement statutory provisions, provided they do not contravene the law. Conventions, such as the principle of collective responsibility in cabinet governance, also influence administrative actions. In S. R. Bomai v. Union of India, 1994 Air 1918, the Supreme Court indirectly upheld the Convention of Federal Cooperation, emphasizing the need for administrative actions to respect constitutional norms. Role of the Right to Information Act, 2005. The RTI Act, 2005, is a transformative legislative source of administrative law, institutionalizing transparency and accountability in governance. By empowering citizens to access information, the Act strengthens the public law character of administrative law, aligning with the constitutional right to free speech under Article 19, 1a. Key provisions of the RTI Act include, Section 4, mandates proactive disclosure of information by public authorities. Section 6, allows citizens to request information without stating reasons. Section 8, enumerates exemptions, such as national security and personal privacy. Section 19, provides for appeals to the Central Information Commission, CIC, or State Information Commission, SIC. In Institute of Chartered Accountants of India v. Shaunak H. Satya, 2011 8 SCC 781, the Supreme Court clarified that the RTI Act does not override statutory confidentiality provisions unless public interest outweighs harm. This case illustrates the balance between transparency and competing public interests under administrative law. The RTI Act also reinforces judicial review, as courts can examine decisions of information commissions. In Namit Sharma v. Union of India, 2013 1 SCC 745, the Supreme Court initially imposed qualifications for information commissioners but later reviewed its decision, highlighting the judiciary's role in shaping administrative accountability. 49 Question 12, Nature and Judicial Control over Delegated Legislation. Discuss the nature of delegated legislation and judicial control over delegated legislation. Section * Nature of delegated legislation. Delegated legislation, also known as subordinate or secondary legislation, is lawmaking by authorities other than the legislature, under powers conferred by a primary statute. It includes rules, regulations, notifications, bylaws, and orders framed by administrative bodies to operationalize parliamentary enactments. According to MP Jain and S.N. Jain, delegated legislation is the exercise of minor legislative power by subordinate authorities in pursuance of statutory authority. Its nature is characterized by its dependence on primary legislation, its operational focus, and its adaptability to changing circumstances. Characteristics of delegated legislation. The following features define the nature of delegated legislation. Subordinate nature. Delegated legislation derives its authority from a parent statute and must conform to its provisions. It cannot override or contradict the primary law. In Hamdard Dawakina v. Union of India, Air 1960 SC 554, the Supreme Court invalidated a rule under the Drugs and Magic Remedies Act, 1954, for exceeding the scope of the parent statute, emphasizing the subordinate character of delegated legislation. Executive dominance. Delegated legislation is typically framed by executive authorities, such as ministries or regulatory bodies, reflecting the executive's role in governance. For example, rules under the RTI Act, 2005, are framed by the central or state governments to regulate information disclosure procedures. Flexibility and specificity. Delegated legislation allows for quick adaptation to technical or situational needs, which the legislature may lack the time or expertise to address. For instance, environmental regulations under the Environment Protection Act, 1986, are frequently updated through delegated legislation to address emerging ecological challenges. Limited scope. The scope of delegated legislation is confined to the powers expressly or impliedly granted by the parent statute. In General Officer Commanding-in-Chief B. Subhash Chandra Yadav, Air 1988 SC 876, the Supreme Court struck down a rule under the Cantonments Act, 1924, for being ultra vires the parent statute. Procedural compliance. Delegated legislation must adhere to procedural requirements, such as publication or consultation, as mandated by the parent statute or general law. Non-compliance may render it invalid, as seen in Harakhand Rathan Chand Banthia v. Union of India, Air 1970 SC 1453. Rationale for delegated legislation. The proliferation of delegated legislation in modern governance is driven by several factors. 50 Legislative overburden. The legislature lacks the time and resources to enact detailed laws for every administrative need. Delegated legislation enables the executive to fill in operational details, as seen in the framing of fee structures under Section 27 of the RTI Act, 2005. Technical expertise. Administrative bodies possess specialized knowledge required for technical regulations, such as those governing telecommunications or public health. For example, the Telecom Regulatory Authority of India, TRAI, frames regulations under the TRAI Act, 1997. Emergency response. Delegated legislation facilitates swift action in emergencies, such as public health crises or national security threats. During the COVID-19 pandemic, rules under the Epidemic Diseases Act, 1897, were issued to enforce lockdowns and health protocols. Experimental approach. Delegated legislation allows for experimentation with policies before enacting permanent laws. Pilot schemes under welfare statutes often rely on delegated legislation. Types of delegated legislation. Delegated legislation manifests in various forms, including rules and regulations, general norms framed under statutory authority, such as the Right to Information Rules, 2012, under the RTI Act, 2005. Notifications, specific announcements or orders, such as exemptions under Section 8 of the RTI Act. Bylaws, rules framed by local bodies or corporations, such as municipal bylaws under the Delhi Municipal Corporation Act, 1957. Orders, directives issued under statutory powers, such as price control orders under the Essential Commodities Act, 1955. Constitutional basis. In India, delegated legislation derives legitimacy from the Constitution. Articles 73 and 162 confer executive powers on the Union and states, respectively, which include the authority to frame delegated legislation. Article 245 empowers Parliament and state legislatures to delegate legislative functions, subject to constitutional limits. In Re-Delhi Laws Act, 1912, Air 1951 SC 332, the Supreme Court upheld the constitutionality of delegated legislation, provided it does not involve the delegation of essential legislative functions and is subject to clear policy guidelines in the parent statute. 51. Judicial control over delegated legislation. Judicial control is a critical safeguard against the misuse of delegated legislative powers, ensuring that subordinate legislation adheres to constitutional and statutory boundaries. The judiciary exercises this control through the doctrine of ultra vires, procedural scrutiny, and constitutional review, balancing administrative efficiency with the rule of law. The following mechanisms illustrate judicial oversight, supported by landmark cases. Doctrine of ultra vires. The doctrine of ultra vires, beyond the powers, is the primary tool for judicial control, ensuring that delegated legislation remains within the scope of the parent statute. Ultra vires can be substantive or procedural. Substantive ultra vires. Substantive ultra vires occurs when delegated legislation exceeds the authority granted by the parent statute or violates constitutional provisions. Key cases include Hamdard Dawakina v. Union of India, Air 1960 SC 554. The Supreme Court struck down a rule under the Drugs and Magic Remedies Act, 1954, which banned advertisements beyond the statute's scope, holding it substantively ultra vires. Indian Express Newspapers v. Union of India, Air 1985 SC 515. The court invalidated a customs notification imposing excessive duties, as it contravened the parent statute's intent and violated Article 19, 1a, General Officer Commanding in Chief v. Subhash Chandra Yadav, Air 1988 SC 876. A rule under the Cantonments Act, 1924, was declared ultra vires for extending beyond the statute's delegated authority. In the context of the RTI Act, 2005, substantive ultra vires could arise if rules framed under Section 27 impose restrictions not contemplated by the Act, such as arbitrary fees that hinder access to information. Procedural ultra vires. Procedural ultra vires occurs when delegated legislation fails to comply with mandatory procedures, such as publication, consultation, or legislative scrutiny. For example, Harakhand Ratan Chand Banthia v. Union of India, Air 1970 SC 1453. The Supreme Court invalidated a rule under the Gold Control Act, 1968, for non-compliance with the mandatory publication requirement. Barium Chemicals Limited v. Company Law Board, Air 1967 SC 295. The court emphasized that procedural safeguards in the parent statute must be strictly followed to ensure fairness. 52. Under the RTI Act, 2005, procedural ultra vires could occur if rules framed under Section 27 are not laid before Parliament, as required by Section 28, rendering them invalid. Constitutional review delegated legislation must conform to constitutional provisions, particularly fundamental rights under Part 3 of the Constitution. Judicial review ensures that subordinate legislation does not violate Articles 14, equality, 19, freedoms, or 21, life and liberty. Landmark cases include, State of Madras v. V.G. Roe, Air 1952 SC 196. The Supreme Court struck down a notification under the Criminal Law Amendment Act, 1908, for imposing unreasonable restrictions on freedom of association under Article 19, 1, c. Maneka Gandhi v. Union of India, Air 1978 SC 597. The court expanded the scope of Article 21, holding that delegated legislation must satisfy the test of reasonableness and procedural fairness. Sri Ramakrishna Dalmia v. Justice S.R. Tendulkar, Air 1958 SC 538. The court upheld a notification under the Commissions of Inquiry Act, 1952, as it was consistent with Article 14's reasonable classification test. In the RTI Act context, rules restricting access to information must align with Article 19, 1, a. In Central Board of Secondary Education v. Aditya Bandyopadhyay, 2011 8 SCC 497, the Supreme Court upheld the right to access examination records under the RTI Act, reinforcing its alignment with constitutional rights. Doctrine of reasonableness. The judiciary examines delegated legislation for reasonableness, ensuring it is not arbitrary or oppressive. In Cruz v. Johnson, 1898 2QB 91, an English case cited in Indian jurisprudence, the court held that bylaws must be reasonable and not partial or unequal in operation. In India, this principle was applied in Air India v. Nirjesh Mirza, Air 1981 SC 1829, where a regulation terminating air hostesses' services upon pregnancy was struck down as arbitrary and violative of Article 14. Exclusion of judicial review. In rare cases, statutes may attempt to exclude judicial review of delegated legislation through ouster clauses. However, in L. Chandrakumar v. Union of India, 1997 3 SCC 261, the Supreme Court held that judicial review is part of the Constitution's basic structure and cannot be excluded, ensuring oversight over delegated legislation. Role of legislative scrutiny. In addition to judicial control, delegated legislation is subject to legislative oversight. Under Article 13, 3, a, delegated legislation qualifies as law and is subject to judicial review for constitutionality. 53 Section 28 of the RTI Act, 2005, requires rules to be laid before Parliament or state legislatures, enabling legislative scrutiny. In Union of India v. S.H. Sheth, Air 1977 SC 2328, the Supreme Court emphasized that legislative oversight complements judicial control, ensuring accountability. RTI Act, 2005, and delegated legislation. The RTI Act, 2005, exemplifies the use of delegated legislation in administrative law. Sections 27 and 28 empower the central and state governments to frame rules for implementing the Act, such as prescribing fees, formats, or appellate procedures. These rules must align with the Act's objective of promoting transparency and accountability. In Institute of Chartered Accountants of India v. Shaunak H. Satya, 2011 8 SCC 781, the Supreme Court clarified that rules under the RTI Act cannot override statutory exemptions under other laws unless public interest prevails. Judicial control ensures that RTI rules do not unduly restrict access to information. For example, excessive fees or cumbersome procedures could be challenged as ultra vires or violative of Article 19, 1, a. The judiciary's role in interpreting RTI provisions, as seen in Namit Sharma v. Union of India, 2013 1 SCC 745, underscores the balance between delegated authority and constitutional rights. Challenges and reforms. Despite its utility, delegated legislation faces challenges, including excessive delegation, lack of transparency, and potential abuse. The absence of clear guidelines in parent statutes may lead to overreach, as seen in Re-Delhi Laws Act, 1912. To address these issues, reforms are necessary. Clear policy guidelines. Parent statutes should provide explicit boundaries for delegated legislation. Enhanced legislative scrutiny. Parliamentary committees should rigorously review delegated legislation. Public consultation, involving stakeholders in rulemaking, as mandated in some statutes, enhances legitimacy. Judicial vigilance. Courts must continue to uphold constitutional principles while respecting administrative autonomy. 54 Question 13. Kinds of writs and distinction between mandamus and certiorari. State the various kinds of writs that can be issued by the High Court and differentiate between the mandamus and certiorari writs. Writs under the Indian Constitution. The Indian Constitution, under Article 226, empowers high courts to issue 5 types of writs: habeas corpus, mandamus, certiorari, prohibition, and quo warranto. These writs serve as tools to enforce constitutional rights and ensure administrative accountability. Habeas corpus. The writ of habeas corpus, meaning you may have the body, is issued to secure the release of a person detained unlawfully. It challenges the legality of detention, ensuring that no individual is deprived of personal liberty without due process. The High Court examines whether the detention is supported by valid legal authority. Case example: ADM Jabalpur v Shivkant Shukla, 1976. In this landmark case, also known as the habeas corpus case, the Supreme Court controversially held during the emergency that the right to move a court for habeas corpus was suspended under Article 359. However, Justice H. R. Khanna's dissenting opinion emphasized the inviolability of personal liberty, underscoring the writ's significance in protecting fundamental rights under Article 21. This case highlights the writ's role in checking arbitrary state action, a cornerstone of administrative law. Mandamus. The writ of mandamus, meaning we command, directs a public authority, tribunal, or government to perform a public or statutory duty that it has failed or refused to perform. It is a command to act, ensuring administrative bodies adhere to their legal obligations. Mandamus cannot be issued against private individuals or to enforce discretionary duties unless the discretion is exercised arbitrarily. Case example: State of Mysore v K. N. Chandrasekhara, 1965. In this case, the Karnataka High Court issued a writ of mandamus directing the state government to consider the petitioner's application for promotion, which was arbitrarily denied. The court held that administrative authorities must act within the bounds of law, and failure to perform a statutory duty warrants judicial intervention. This case illustrates mandamus as a tool to enforce administrative accountability. Certiorari. The writ of certiorari, meaning to be certified, is issued by a superior court to quash the order or decision of an inferior court, tribunal, or quasi-judicial authority when it acts without jurisdiction, 55 exceeds its jurisdiction, or violates principles of natural justice. It corrects jurisdictional errors and ensures fairness in administrative decision-making. Case example: A.K. Krapak v Union of India, 1970. In this case, the Supreme Court issued a writ of certiorari to quash the selection process for the Indian Forest Service due to bias and violation of natural justice principles. The court held that administrative actions must adhere to fairness, and certiorari is an effective remedy to correct procedural irregularities. This case underscores the writ's role in judicial review of administrative actions. Prohibition. The writ of prohibition is issued to prevent an inferior court or tribunal from proceeding with a case beyond its jurisdiction or in violation of legal principles. Unlike certiorari, which corrects completed actions, prohibition is preventive, halting ongoing proceedings. Case example: East India Commercial Co. Limited v. Collector of Customs, 1962. The Supreme Court issued a writ of prohibition to restrain a customs authority from proceeding with an inquiry lacking jurisdiction. The court emphasized that prohibition ensures administrative bodies operate within their legal limits, reinforcing the principles of administrative law. Quo warranto, the writ of quo warranto, meaning by what authority, challenges the legality of a person holding a public office. It is issued to oust an individual from an office they are not entitled to hold, ensuring lawful appointments. Case example, University of Mysore v. Govinda Rao, 1965, the Supreme Court issued a writ of quo warranto to examine the validity of an appointment to a university post. The court held that the appointment violated statutory qualifications, and the writ was an appropriate remedy to ensure lawful occupation of public offices. Differentiation between mandamus and certiorari. While both mandamus and certiorari are integral to judicial review under administrative law, they serve distinct purposes and operate in different contexts. Below is a detailed differentiation based on their nature, scope, purpose, and application. Nature and purpose. Mandamus is a positive or affirmative writ, commanding a public authority to perform a specific duty mandated by law. It is invoked when an authority refuses or neglects to act, compelling action to uphold legal obligations. For instance, in Comptroller and Auditor General v. K.S. Jagannathan, 1986, the Supreme Court issued mandamus to direct the government to promote employees as per statutory rules, emphasizing its role in enforcing administrative duties. In contrast, certiorari is a corrective or negative writ, aimed at quashing an order or decision of a lower court or tribunal that is legally flawed due to jurisdictional errors, procedural irregularities, or 56 violation of natural justice. In T.C. Bisapa v. T. Nagapa, 1954, the Supreme Court clarified that certiorari corrects errors apparent on the face of the record, ensuring judicial and quasi-judicial bodies adhere to legal standards. Scope of application. Mandamus applies to administrative, ministerial, or statutory duties, compelling action when an authority has a clear legal obligation. It cannot be used for discretionary duties unless the discretion is exercised mala fide or arbitrarily. For example, in State of Punjab v. G.S. Gill, 1997, mandamus was issued to enforce the implementation of a government policy that the state had failed to execute. Certiorari, however, is limited to judicial or quasi-judicial actions, correcting errors in jurisdiction or procedure. It does not apply to purely administrative functions unless they involve quasi-judicial elements. In Surya Dev Rai v. Ramchandar Rai, 2003, the Supreme Court distinguished certiorari as a remedy to quash decisions of tribunals or courts acting beyond their authority. Grounds for issuance. The grounds for issuing mandamus include, refusal to perform a public or statutory duty, arbitrary or mala fide exercise of discretion, violation of fundamental or legal rights due to inaction. For instance, in Union of India v. S.B. Vora, 2004, mandamus was issued to compel the government to grant pension benefits to an employee, as the denial was arbitrary. The grounds for issuing certiorari include, lack of jurisdiction or excess of jurisdiction, violation of principles of natural justice, e.g., audi alteram partem, error of law apparent on the face of the record. In Hari Vishnu Kamath v. Ahmed Ishaq, 1955, the Supreme Court issued certiorari to quash a tribunal's decision due to a jurisdictional error, reinforcing its corrective nature. Authority against which issued mandamus can be issued against a wide range of authorities, including administrative bodies, government officials, or public corporations, provided they have a public duty. For example, in Rashid Ahmed v. Municipal Board, Karana, 1950, mandamus was issued to compel a municipal board to grant a license wrongfully denied. Certiorari is issued only against judicial or quasi-judicial authorities, such as courts, tribunals, or statutory bodies performing adjudicatory functions. In Province of Bombay v. Kushaldas S. Advani, 1950, the Supreme Court clarified that certiorari applies to bodies exercising judicial functions, not purely administrative ones. 57 Relation to Right to Information Act, 2005. The Right to Information Act, 2005, empowers citizens to access information from public authorities, promoting transparency and accountability. Both mandamus and certiorari play significant roles in enforcing RTI provisions. Mandamus is frequently used to compel public authorities to disclose information under the RTI Act when they fail to comply with statutory obligations. In Chief Information Commissioner v. State of Manipur, 2011, the Manipur High Court issued mandamus to direct the State Information Commission to dispose of pending RTI applications, emphasizing the writ's role in enforcing transparency. Certiorari is used to quash orders of information commissioners or appellate authorities under the RTI Act when they act beyond their jurisdiction or violate natural justice. In Central Board of Secondary Education v. Aditya Bandyopadhyay, 2011, the Supreme Court used certiorari to review and uphold the disclosure of answer sheets under the RTI Act, correcting an erroneous interpretation by the authorities. Landmark cases and judicial trends. The judiciary has played a pivotal role in shaping the application of mandamus and certiorari. In Bharadakanta Mishra v. High Court of Orissa, 1976, the Supreme Court clarified that certiorari is appropriate for correcting jurisdictional errors, while mandamus compels action in cases of administrative inaction. Similarly, in Maneka Gandhi v. Union of India, 1978, the court emphasized the expansive scope of Article 226, allowing high courts to issue writs to protect fundamental and legal rights. In the context of the RTI Act, mandamus has been instrumental in ensuring compliance with transparency obligations, as seen in State of Uttar Pradesh v. Rajnarain, 1975, a pre-RTI case that laid the foundation for the right to know. Certiorari has been used to review decisions of information commissioners, as in Union Public Service Commission v. Shiv Shankar, 2013, where the court quashed an order for disclosure due to procedural irregularities. 58 Question 14, Principles of Natural Justice in Administrative Adjudication and Exceptions. Discuss the principles of natural justice in reference to administrative adjudication and state its exceptions. Principles of natural justice. Natural justice comprises two fundamental principles, the rule against bias and the right to a fair hearing. These principles ensure that administrative decisions are fair, transparent, and just, aligning with the constitutional mandate of fairness and equality. Rule against bias, nemo judex in causa sua, the principle of nemo judex in causa sua, meaning no one should be a judge in their own cause, prohibits bias in administrative adjudication. Bias may be pecuniary, personal, or official, and even the likelihood of bias is sufficient to vitiate a decision. This principle ensures that the adjudicating authority remains impartial and independent. Case example, A.K. Krapak v. Union of India, 1970, in this landmark case, the Supreme Court quashed a selection process for the Indian Forest Service due to bias. A member of the selection board was a candidate, violating the rule against bias. The court held that even in administrative proceedings with quasi-judicial elements, the presence of bias undermines fairness. This case expanded the application of natural justice to administrative functions, emphasizing impartiality in decision-making. Application in RTI Act, 2005. Under the Right to Information Act, 2005, the rule against bias is relevant when information commissioners adjudicate appeals. Section 19 of the RTI Act mandates impartiality in the appellate process. In Chief Information Commissioner v. State of Manipur, 2011, the Manipur High Court emphasized that information commissioners must act without bias to ensure fair disposal of RTI appeals, reinforcing the principle's relevance in transparency-related adjudication. Right to a fair hearing, audi alteram partem, the principle of audi alteram partem, meaning hear the other side, ensures that no person is condemned without an opportunity to be heard. It includes the right to notice, the right to present one's case, the right to cross-examine, and the right to a reasoned decision. This principle is critical in administrative adjudication to prevent arbitrary decisions. Case example, Maneka Gandhi v. Union of India, 1978, in this seminal case, the Supreme Court held that the impounding of the petitioner's passport without a hearing violated audi alteram partem. The court expanded the scope of Article 21, stating that any procedure affecting fundamental rights must be just, fair, and reasonable. The decision underscored the necessity of a fair hearing in administrative actions, even when not explicitly required by statute. Application in RTI Act, 2005-50. The RTI Act incorporates audi alteram partem in its appellate mechanism under sections 19.3 and 19.4, which require the first appellate authority and central/state information commission to give applicants a reasonable opportunity to be heard. In Central Board of Secondary Education via Didia Bandopad 2011, the Supreme Court upheld the right to access answer sheets under the RTI Act, emphasizing that fair hearing principles apply to ensure transparency in adjudication. Reasoned decision, speaking order, a corollary to audi alteram partem is the requirement for administrative authorities to provide reasoned decisions, also known as speaking orders. This ensures transparency and enables judicial review of administrative actions. Case example, S. N. Mukherjee v. Union of India, 1990, the Supreme Court held that administrative authorities exercising quasi-judicial functions must provide reasons for their decisions unless expressly excluded by statute. In this case, the court quashed an order dismissing an army officer because it lacked reasons, violating natural justice. This principle ensures accountability and aligns with the RTI Act's objective of transparency. Application in administrative adjudication. Administrative adjudication refers to the process by which administrative authorities resolve disputes or make decisions with judicial characteristics. Natural justice principles are integral to ensuring fairness in such processes, particularly in licensing, disciplinary proceedings, and statutory appeals. Licensing and permits. In licensing disputes, authorities must adhere to natural justice. In Farooq Abdul Rahim v. State of Maharashtra, 1996, the Bombay High Court quashed a licensing decision because the applicant was not given a hearing, violating audi alteram partem. The RTI Act reinforces this by requiring public authorities to disclose reasons for denying licenses under Section 4.1d. Disciplinary proceedings. In disciplinary proceedings, natural justice ensures that employees are not penalized without a fair process. In State of Orissa v. Binapani DEI, 1967, the Supreme Court invalidated a compulsory retirement order because the employee was not given a hearing, emphasizing the universal applicability of audi alteram partem in quasi-judicial proceedings. RTI adjudication. The RTI Act's appellate process under Sections 19 and 20 relies heavily on natural justice. Authorities must provide notice, allow hearings, and issue reasoned orders. In Union Public Service Commission v. Shiv Shankar, 2013, the Delhi High Court quashed an Information Comma 60 Zionist order for lacking reasons, highlighting the importance of speaking orders in RTI adjudication. Exceptions to natural justice. While natural justice is a fundamental requirement, there are recognized exceptions where these principles may be excluded or limited. These exceptions are justified based on practical necessities, statutory provisions, or overriding public interest. Statutory exclusion. When a statute expressly or impliedly excludes natural justice, courts may uphold such exclusion, provided it aligns with constitutional mandates. However, such exclusions are narrowly construed. Case example, Union of India v. Tulsiram Patel, 1985. In this case, the Supreme Court held that Article 311(2) of the Constitution, which provides for a hearing in disciplinary proceedings, can be excluded in cases of public interest, such as national security. The court ruled that statutory exclusion of natural justice is permissible if the statute provides clear intent and is not arbitrary. Emergency situations. In situations requiring immediate action, such as public safety or national security, natural justice may be dispensed with. However, post-decisional hearings may be provided to balance fairness. Case example, Swadeshi Cotton Mills v. Union of India, 1981, the Supreme Court upheld the takeover of a company without a prior hearing due to economic urgency. However, the court emphasized that a post-decisional hearing must be provided to comply with fairness, illustrating a partial exception to audi alteram partem. Impracticability when applying natural justice is impractical due to the scale or nature of the administrative action, courts may relax its requirements. Case example, R.S. Das v. Union of India, 1987, in a mass disciplinary proceeding involving multiple employees, the Supreme Court held that individual hearings were impractical. The court allowed a collective inquiry but insisted on minimum fairness, such as notice and representation, to prevent arbitrariness. Public interest may override natural justice, particularly in cases involving national security or public welfare. Case example, ADM Jabalpur v. Shivkant Shukla, 1976, during the emergency, the Supreme Court controversially held that the right to a hearing could be 61 suspended in the interest of national security. Justice H.R. Khanna's dissent, however, argued that natural justice is integral to the rule of law, highlighting the contentious nature of this exception. Preliminary or administrative actions. Natural justice does not apply to purely administrative or preliminary actions without adjudicatory consequences. Case example, State of Assam v. Bharat Kala Bandar, 1967, the Supreme Court held that a preliminary inquiry into allegations of misconduct did not require a hearing, as it was not a final adjudicatory action. However, if the inquiry leads to adverse consequences, natural justice applies at the final stage. Legislative functions. Actions of a legislative nature, such as rulemaking, are exempt from natural justice, as they do not involve individual rights adjudication. Case example, Bates v. Lord Hailsham, 1972, although a UK case, it is relevant in Indian jurisprudence. The court held that a decision to amend legal aid rules was a legislative function, not requiring a hearing. In India, similar reasoning applies to rulemaking under the RTI Act, such as framing rules under Section 27. RTI Act and exceptions. The RTI Act, 2005, provides exceptions to disclosure under Section 8, which indirectly limit the application of natural justice. For instance, information affecting national security or commercial confidence may be withheld without a hearing. In Bihar Public Service Commission v. Syed Hussain Abbas Rizvi, 2012, the Supreme Court upheld the denial of information under Section 8(1)(j), without a hearing, as it was statutorily exempt, illustrating the interplay between statutory exclusions and natural justice. Judicial trends and developments. The Indian judiciary has dynamically interpreted natural justice, expanding its scope while recognizing practical limitations. In Ridge v. Baldwin, 1964, a UK case influential in India, the House of Lords emphasized that natural justice applies to administrative actions with significant consequences. In India, Board of High School and Intermediate Education v. Ghanshyam Das, 1962, reinforced this by quashing an examination cancellation order for lack of a hearing. In the context of the RTI Act, cases like Institute of Chartered Accountants of India v. Shaunak H. Sathya, 2011, highlight the judiciary's insistence on reasoned orders in RTI appeals, aligning with natural justice. However, courts have also upheld exceptions in cases like R.K. Jain v. Union of India, 1993, where disclosure was denied to protect third-party interests under Section 11 of the RTI Act. 62. Question 15, Administrative Tribunal, Definition and Characteristics. What do you mean by administrative tribunal? Discuss its characteristics. Definition of administrative tribunal. An administrative tribunal is a quasi-judicial body established under statutory provisions to adjudicate disputes involving administrative actions or decisions. Unlike ordinary courts, tribunals are specialized entities tailored to handle specific categories of disputes, such as service matters, taxation, or environmental regulations. They combine judicial impartiality with administrative expertise, ensuring swift and informed resolutions. According to Bharat Bank Limited v. Employees, AIR 1950 SC 188, the Supreme Court clarified that tribunals, though not courts in the strict sense, perform judicial functions by adjudicating disputes impartially. The Constitution of India, under Articles 323A and 323B, introduced in 1976 by the 42nd Amendment, provides the legal foundation for establishing administrative tribunals for service matters and other specified subjects, respectively. Characteristics of administrative tribunals. Administrative tribunals possess distinct features that differentiate them from traditional courts. These characteristics reflect their hybrid nature, balancing judicial independence with administrative efficiency. Below is a comprehensive analysis of their key attributes. Statutory origin. Administrative tribunals derive their authority from specific statutes enacted by the Parliament or state legislatures. For instance, the Administrative Tribunals Act, 1985, established Central Administrative Tribunals, CAT, and State Administrative Tribunals, SAT, to adjudicate service disputes of public servants. Similarly, the Income Tax Appellate Tribunal, ITAT, operates under the Income Tax Act, 1961. This statutory origin ensures that tribunals function within a defined legal framework, with their jurisdiction, powers, and procedures explicitly delineated. Example, in Union of India v. R. Gandhi, 2010, 11 SCC 1, the Supreme Court upheld the statutory creation of the National Company Law Tribunal, NCLT, under the Companies Act, 1956, emphasizing that such tribunals must adhere to principles of natural justice and judicial independence. Quasi-judicial nature. Tribunals are quasi-judicial bodies, meaning they perform judicial functions without being full-fledged courts. They adjudicate disputes by applying legal principles, hearing parties, and delivering binding decisions, yet they adopt flexible procedures compared to courts. This quasi-judicial character enables tribunals to combine legal expertise with domain-specific knowledge. Case study, in Associated Cement Companies Limited v. P. N. Sharma, Air 1965 SC 1595, the Supreme Court held that a tribunal, such as the Labor Appellate Tribunal, exercises quasi-judicial 63 functions when it determines disputes based on evidence and legal principles, ensuring fairness and impartiality. Specialized jurisdiction. Unlike courts with general jurisdiction, administrative tribunals focus on specific areas, such as service matters, taxation, or environmental disputes. This specialization allows tribunal members, often comprising legal and technical experts, to develop deep expertise, enhancing the quality of adjudication. Example, the Central Administrative Tribunal, CAT, established under the Administrative Tribunals Act, 1985, exclusively handles disputes related to recruitment, conditions of service, and disciplinary actions of central government employees. In L. Chandrakumar v. Union of India, 1997, 3 SCC 261, the Supreme Court underscored the specialized role of CAT, noting its ability to address service disputes efficiently. Flexible procedure. Tribunals are not bound by the rigid procedural rules of the Code of Civil Procedure, 1908, or the Indian Evidence Act, 1872. Instead, they follow principles of natural justice, ensuring fairness while adopting simplified procedures. This flexibility accelerates dispute resolution, making tribunals accessible and cost-effective. Example, the National Green Tribunal, NGT, established under the National Green Tribunal Act, 2010, adopts summary procedures to resolve environmental disputes swiftly. In Wilfred J. v. Ministry of Environment and Forests, 2016, the NGT's flexible approach was lauded for balancing ecological concerns with expeditious justice. Expert composition. Administrative tribunals often comprise a mix of judicial and technical members, ensuring a holistic approach to adjudication. Judicial members provide legal expertise, while technical members contribute domain-specific knowledge, enhancing the tribunal's competence. Case study, in S.P. Sampath Kumar v. Union of India, 1987, 1 SCC 124, the Supreme Court upheld the composition of CAT, comprising judicial and administrative members, as a mechanism to ensure informed decision-making in service disputes. Finality of decisions. Tribunal decisions are generally final, subject to limited judicial review by high courts or the Supreme Court under Articles 226, 227, or 32 of the Constitution. This finality reduces litigation delays, providing certainty to litigants. However, the scope of judicial review was clarified in L. Chandra Kumar v. Union of India, where the Supreme Court held that tribunal decisions are subject to scrutiny for jurisdictional errors, violation of natural justice, or arbitrariness. Example, in R. K. Jain v. Union of India, 1993, 4 SCC 119, the Supreme Court emphasized that while the Customs, Excise, and Service Tax Appellate Tribunal, CESTAT, decisions are final, 64 they remain amenable to judicial review to ensure compliance with legal norms. Accessibility and cost-effectiveness. Tribunals are designed to be user-friendly, with simplified filing procedures and lower costs compared to courts. This accessibility ensures that individuals, including public servants and citizens, can seek redress without financial or procedural barriers. Example, the RTI Act, 2005, complements tribunal accessibility by mandating transparency in their functioning. In Central Board of Secondary Education v. Aditya Bandyopadhyay, 2011, 8 SCC 497, the Supreme Court upheld the right to access examination records under the RTI Act, reinforcing the transparency obligations of tribunals like CAT. Role of the Right to Information Act, 2005. The RTI Act, 2005, plays a pivotal role in enhancing the transparency and accountability of administrative tribunals. Under Section 4, tribunals, as public authorities, are obligated to proactively disclose information about their organization, functions, and decisions. Section 6 enables citizens to seek information, ensuring public scrutiny of tribunal proceedings. Case study, in Registrar, Supreme Court of India v. Subhash Chandra Agarwal, 2010, the Delhi High Court held that judicial and quasi-judicial bodies, including tribunals, are subject to RTI disclosures unless exempted under Section 8. This ruling underscores the RTI Act's role in fostering trust in tribunal operations. Constitutional Framework and Judicial Oversight. Articles 323A and 323B of the Constitution empower the Parliament and state legislatures to establish administrative tribunals. However, their autonomy is balanced by judicial oversight to prevent arbitrariness. The landmark case of L. Chandra Kumar v. Union of India redefined the constitutional status of tribunals, striking down provisions that excluded High Court jurisdiction under Articles 226 and 227. The court held that tribunals are supplementary to courts, not substitutes, and their decisions remain subject to judicial review. Implications: this ruling ensured that tribunals operate within the constitutional framework, maintaining the balance between efficiency and accountability. It also reinforced the judiciary's role as the guardian of fundamental rights. Critical analysis: while administrative tribunals enhance administrative efficiency, they face challenges, including delays, lack of uniformity in procedures, and concerns about judicial independence. The reliance on administrative members, often retired bureaucrats, raises questions about impartiality. Moreover, the limited scope of judicial review, though necessary for finality, may restrict access to justice in complex cases. 65. The RTI Act addresses some of these concerns by promoting transparency, but its implementation remains inconsistent. Tribunals must strengthen their proactive disclosure mechanisms to align with the RTI Act's objectives fully. 66. Question 16, Need, Importance and Key Features of the Administrative Tribunal, Amendment, Act, 2006 discuss the need, importance, and key features of the Administrative Tribunal, Amendment, Act, 2006. Need for the Administrative Tribunal, Amendment, Act, 2006. The Administrative Tribunals Act, 1985, was enacted to provide speedy and specialized adjudication for service disputes involving public servants. However, over time, several challenges emerged, necessitating amendments to enhance the tribunal's efficacy and align them with constitutional principles. The need for the 2006 amendment arose from the following factors: judicial pronouncements highlighting structural flaws. The Supreme Court's ruling in L. Chandrakumar v. Union of India, 1997, 3 SCC 261 was a pivotal trigger for the 2006 amendment. The court held that excluding High Court jurisdiction under Articles 226 and 227 over tribunal decisions was unconstitutional, as judicial review forms part of the Constitution's basic structure. This ruling exposed the need to reform the Act to ensure tribunals function as supplementary bodies under judicial oversight, rather than substitutes for high courts. Example, in S.P. Sampath Kumar v. Union of India, 1987, 1 SCC 124, the Supreme Court upheld the validity of the 1985 Act but emphasized the need for tribunals to maintain judicial independence, suggesting amendments to enhance their autonomy and credibility. Operational inefficiencies. Administrative tribunals, particularly the Central Administrative Tribunal, CAT, faced issues like delays, inadequate infrastructure, and vacancies in judicial and administrative posts. The 2006 amendment sought to streamline appointments, tenure, and administrative processes to reduce pendency and improve efficiency. Statistical insight. As per the 272nd Law Commission Report, 2017, CAT had a pendency of 44,333 cases, underscoring the urgency for procedural reforms to expedite dispute resolution. https://vihiraexam/tribunal/ enhancing judicial independence. Concerns about executive influence in tribunal appointments and functioning prompted the need for reform. The 2006 amendment aimed to align tribunal composition with the principles of separation of powers, ensuring that chairpersons and members operate independently of administrative interference. Case study, in Union of India v. R. Gandhi, 2010, 11 SCC 1, the Supreme Court emphasized that tribunal members must possess qualifications equivalent to High Court judges to maintain judicial integrity, reinforcing the need for statutory amendments to elevate tribunal standards. 67 Alignment with transparency mandates. The RTI Act, 2005, imposed obligations on public authorities, including tribunals, to ensure transparency in their operations. The 2006 amendment addressed the need to make tribunals more accountable by clarifying their administrative structure and appointment processes, facilitating public scrutiny under the RTI framework. Importance of the Administrative Tribunal Amendment, Act, 2006. The 2006 amendment holds profound significance in strengthening India's administrative justice system. Its importance can be analyzed through the following dimensions: strengthening judicial oversight. By aligning with the L. Chandrakumar ruling, the amendment ensured that tribunal decisions remain subject to High Court review under Articles 226 and 227. This reinforces the judiciary's role as the guardian of constitutional rights, preventing tribunals from operating in isolation. Example, in R.K. Jain v. Union of India, 1993, 4 SCC 119, the Supreme Court clarified that tribunals like the Customs, Excise, and Service Tax Appellate Tribunal, CESTAT, are subject to judicial review for errors of jurisdiction or violations of natural justice, a principle upheld by the 2006 amendment. Enhancing efficiency and accessibility. The amendment streamlined tribunal procedures, clarified member qualifications, and reduced administrative bottlenecks, making tribunals more accessible to public servants. The nominal filing fee of Rs 50 and the option for self-representation before CAT exemplify its commitment to affordability. https://cis.cat.governmentin/catlive/introduction.php. Statistical impact. Since its inception in 1985 until June 2022, CAT disposed of 8,04,272 out of 8,82,085 cases, achieving a disposal rate of 91.18%, reflecting improved efficiency post-amendment. https://sys.cat.governmentin/catlive/introduction.php, promoting judicial independence by elevating the status of tribunal members to that of High Court judges and mandating consultations with the Chief Justice of India for appointments. The amendment safeguarded tribunals from executive dominance, aligning with the doctrine of separation of powers. Case study, in Madras Bar Association v Union of India, 2014, 10 SCC 1, the Supreme Court reiterated the need for judicial dominance in tribunal appointments, a principle reinforced by the 2006 amendments provisions. Fostering transparency under RTI Act. The amendments focus on clear appointment and tenure rules, enhanced tribunals' accountability, aligning with the RTI Act's mandate for proactive disclosure under Section 4. This ensures public 68 access to tribunal processes, fostering trust. Example, in Registrar, Supreme Court of India v Subhash Chandra Agarwal, 2010, the Delhi High Court held that quasi-judicial bodies like tribunals are subject to RTI disclosures, a principle supported by the 2006 amendments' transparency measures. Key features of the Administrative Tribunal Amendment Act 2006. The 2006 amendment introduced several critical changes to the Administrative Tribunals Act, 1985, enhancing its operational framework. The key features are analyzed below. Abolition of vice-chairman post. The amendment substituted the term vice-chairman with member in Section 3 and abolished the vice-chairman post under Section 5. This streamlined the tribunal hierarchy, reducing administrative complexity and ensuring uniformity in member roles. Implication: the removal of the vice-chairman post centralized authority under the chairman, enhancing decision-making efficiency. However, existing vice-chairmen with at least 2 years of service remained eligible for appointment as chairman. https://lawyerslaw.org/The Administrative Tribunal Amendment Act 2006/ Enhanced Qualifications for Chairman. Section 6 was amended to stipulate that the chairman of a tribunal must be a sitting or retired High Court judge or a vice-chairman, pre-amendment, with at least 2 years of service. This elevated the tribunal's judicial stature, aligning it with High Court standards. Example, the appointment of Justice Ranjit Basantara Omore, retired Chief Justice of Meghalaya High Court, as CAT chairman reflects the amendment's emphasis on judicial expertise. https://sys.cga Status equivalent to High Court judges. The amendment granted tribunal members the status, salary, and privileges equivalent to High Court judges, enhancing their independence and attracting qualified professionals. Members are drawn from both judicial and administrative streams, ensuring a balanced composition. https://vihiramandraexam/administrative tribunal/ case study, in Union of India v R Gandhi, the Supreme Court upheld similar provisions for the National Company Law Tribunal, NCLT, emphasizing that high qualifications ensure tribunal credibility. Tenure and reappointment provisions. The amendment specified that the chairman's tenure is 5 years or until age 68, whichever is earlier, while members serve up to 10 years or age 65. Members appointed before the amendment could be considered for reappointment under the new criteria, subject to the total tenure cap. https://indianqanun.org/doc/195735/69 Implication: these provisions provide stability while preventing prolonged tenures, balancing expertise with fresh perspectives. Consultation with Chief Justice of India. The amendment mandated consultation with the Chief Justice of India for appointing chairman and members of central, state, and joint administrative tribunals, reinforcing judicial independence. For state and joint tribunals, consultation with respective governors was also required. https://pairsindia.org Administrative Tribunals Amendment Bill 2012, example, this provision aligns with the Supreme Court's directive in SP Sampath Kumar, ensuring that tribunal appointments reflect judicial oversight. Removal of contempt powers. The amendment abolished tribunals' powers to punish for contempt of court, previously equivalent to high courts, placing them under high court jurisdiction for contempt matters. This ensured consistency with the L. Chandra Kumar ruling, subordinating tribunals to judicial oversight. https://pearsindia.org Administrative Tribunals Amendment Bill 2006. Implication: this change clarified the tribunals' quasi-judicial role, preventing overreach while maintaining their authority to adjudicate service disputes. Appeal to high courts. The amendment formalized the right to appeal tribunal decisions before the division bench of the concerned high court within 60 days, codifying the L. Chandra Kumar ruling. This ensured access to judicial review without bypassing high courts. https://vahiramandrabi.com/upskexam/administrative tribunal/ example, in Central Board of Secondary Education via Ditya Bandopad 2011, 8 SCC 497, the Supreme Court upheld the right to seek judicial review of quasi-judicial decisions, a principle reinforced by the amendment. Interplay with Right to Information Act, 2005. The RTI Act, 2005, complements the 2006 amendment by ensuring transparency in tribunal operations. Section 4 mandates proactive disclosure of tribunal rules, member appointments, and case statuses, while Section 6 allows citizens to seek information. The amendment's clarity on appointments and tenure facilitates compliance with these obligations. Case study, in Institute of Chartered Accountants of India v. Shaunak H. Satya, 2011, 8 SCC 781, the Supreme Court emphasized that public authorities, including tribunals, must maintain transparency under the RTI Act, aligning with the amendment's objectives. 70 Critical analysis. The 2006 amendment significantly improved the tribunal system by addressing judicial, operational, and transparency concerns. However, challenges persist. Pendency issues. Despite procedural reforms, tribunals like CAT and NCLT face backlogs due to vacancies and resource constraints. https://aptaplus.in/blog/tribunals in India/ executive influence. While consultation with the Chief Justice of India reduces executive dominance, the lack of an independent National Tribunals Commission, NTC, as recommended by the Supreme Court in 2020, limits autonomy. https://pearsindia.org/billtrack/pearce-products/the tribunal system in India. Uniformity in procedures. The absence of a uniform procedural code across tribunals leads to inconsistencies, undermining predictability. https://aptaplus.in/blog/tribunals in India/ The amendment's alignment with the RTI Act enhances accountability, but inconsistent implementation of proactive disclosures remains a concern. Future reforms should focus on establishing the NTC, standardizing procedures, and addressing vacancies to fully realize the amendment's objectives. 71 Question 17, LPL, meaning, appointment steps, merits and demerits. What do you mean by LPL? What steps have been taken in India in regards of appointment of LPL? Discuss merits and demerits of this institution. Concept of LPL. The LPL is an anti-corruption authority designed to inquire into allegations of corruption against public servants, including the Prime Minister, with exceptions, ministers, members of Parliament, MPs, and Group A, B, C, and D officials of the central government. It also covers entities receiving foreign contributions above 10 lakh under the Foreign Contribution Regulation Act, 2010. The institution draws inspiration from the ombudsman model, first established in Sweden in 1809, and adapted globally to promote accountability. In India, the concept was coined by Dr. L. M. Singhvi in 1963 and proposed as a constitutional ombudsman by Law Minister Ashok Kumar Sen in the early 1960s. The LPL and Lokayuktas Act, 2013, establishes the LPL as a multi-member body, comprising a chairperson and up to 8 members, with 50% being judicial members and at least 50% from scheduled castes, scheduled tribes, other backward classes, minorities, and women. The chairperson must be a former Chief Justice of India, a former Supreme Court judge, or an eminent person with at least 25 years of expertise in anti-corruption policy, public administration, vigilance, finance, law, or management. The LPL's primary function is to investigate corruption complaints, ensuring transparency and accountability, aligning with administrative law principles of fairness and public interest. The LPL operates as an ombudsman, distinct from traditional judicial or administrative bodies, by focusing on proactive inquiry and prosecution. It has the power of superintendence over investigative agencies like the Central Bureau of Investigation, CBI, for referred cases and can authorize search and seizure operations. Unlike advisory bodies like the Central Vigilance Commission, CVC, the LPL has binding powers, including the ability to recommend prosecution and confiscate assets acquired through corrupt means. In the context of administrative law, the LPL strengthens the rule of law by ensuring that public authorities are accountable. Its alignment with the RTI Act, 2005, enhances transparency, as citizens can access information to substantiate corruption complaints. In Common Cause v. Union of India, 2017, the Supreme Court emphasized the urgency of operationalizing the LPL, highlighting its role in upholding public trust. Steps taken for appointment of LPL in India. The journey to establish the LPL in India has been protracted, marked by legislative delays, public movements, and judicial interventions. The following outlines the key steps in its appointment process: 72 Historical context and legislative efforts. 1960s 1980s. The concept of LPL was first proposed in the early 1960s by Ashok Kumar, Senator. The First Administrative Reforms Commission, 1966-1970, chaired by Morarji Desai, recommended establishing LPL and Lokayuktas to address corruption. The LPL bill was introduced in the Lok Sabha in 1968 and passed in 1969 but lapsed due to the dissolution of the Rajya Sabha. Subsequent attempts in 1971, 1977, 1985, and 1989 also failed due to political resistance. 1990s 2000s, further attempts to pass the LPL bill in 1996, 1998, 2001, 2005, and 2008 were unsuccessful, reflecting a lack of political will. In 2002, the National Commission to Review the Working of the Constitution, headed by M.N. Venkatakalaya, and in 2005, the Second Administrative Reforms Commission, chaired by Veerappa Moily, reiterated the need for LPL. India Against Corruption Movement, 2011, the turning point came with the India Against Corruption, IAC, movement led by Anna Hazare in 2011, which galvanized public support for a strong anti-corruption ombudsman. The movement demanded the Jan LPL bill, drafted by Justice Santosh Hegde, Prashant Bhushan, and Arvind Kejriwal, which proposed an independent body with powers to prosecute without government permission. The public outcry pressured the United Progressive Alliance, UPA, government to introduce the LPL and Lokayuktas Bill, 2011, in Parliament. Passage of the LPL and Lokayuktas Act, 2013. 2011-2013, the LPL and Lokayuktas Bill, 2011, was tabled in the Lok Sabha on December 22, 2011, and passed on December 27. It faced delays in the Rajya Sabha but was passed on December 17, 2013, after amendments. The bill received presidential assent on January 1, 2014, and came into force on January 16, 2014. 2016 Amendment, the LPL and Lokayuktas, Amendment, Act, 2016, modified the selection process to include the leader of the single largest opposition party in the Lok Sabha in the absence of a recognized leader of opposition. It also amended provisions related to asset and liability disclosures. Appointment process: the LPL's chairperson and members are appointed by the President based on recommendations from a selection committee comprising the Prime Minister, chairperson. The Speaker of the Lok Sabha. The leader of opposition in the Lok Sabha, or leader of the single largest opposition party. 73. The Chief Justice of India or a nominated Supreme Court judge. An eminent jurist nominated by the President. A search committee, headed by a former Supreme Court judge, e.g., Justice Ranjana Prakash Desai in 2018, prepares a panel of candidates for the selection committee's consideration. The search committee must include at least 7 members with expertise in anti-corruption policy, public administration, vigilance, finance, law, or management, with 50% representation from marginalized communities. Key appointments 2019, following a Supreme Court directive in Common Cause v Union of India, 2017, which criticized delays in appointing the Lokpal, Justice Pinaki Chandra Ghose was appointed as India's first Lokpal chairperson on March 19, 2019, along with 8 members. 2024, after Justice Ghose's tenure, Justice Ajay Manikro Kanwilkar was appointed chairperson in March 2024, nearly 2 years after the post became vacant. Challenges in appointment delays in appointing the Lokpal were attributed to the absence of a recognized leader of opposition in the Lok Sabha, 2014-2019, as the Congress party did not secure the requisite seats. The government cited this as a reason for inaction, prompting the 2016 amendment. Additionally, the non-appointment of a director of inquiry, as revealed through an RTI reply in 2021, highlighted ongoing administrative gaps. The Supreme Court's intervention ensured progress, emphasizing judicial oversight in administrative law. Merits of the Lokpal institution. The Lokpal institution offers several advantages in combating corruption and enhancing administrative accountability, aligning with the objectives of administrative law and the RTI Act, 2005. Comprehensive jurisdiction. The Lokpal covers a wide range of public servants, including the Prime Minister, with safeguards, ministers, MPs, and Group AD officials, as well as entities receiving significant foreign contributions. This ensures accountability across governance levels. Investigative and prosecutorial powers. The Lokpal can initiate inquiries, direct investigations through agencies like the CBI, and recommend prosecution. It has powers akin to a civil court for preliminary inquiries and can authorize search and seizure. In Central Board of Secondary Education via Ditya Bandopadhyay, 2011 8 SCC 497, the Supreme Court's emphasis on transparency under the RTI Act complements the Lokpal's investigative role. 74 Independence from government control. The Lokpal selection process, involving a diverse committee, aims to ensure impartiality. Its power to oversee CBI investigations reduces political interference, addressing concerns raised in Vineet Narain v Union of India, 1998 1 SCC 226, where the court criticized the CBI's lack of autonomy. Timelines for action. The Act specifies timelines: 3 months for preliminary inquiries, extendable by 3 months, 6 months for investigations, extendable by 6 months, and 1 year for trials, extendable by 1 year, ensuring expeditious resolution. Public empowerment. By allowing citizens to file complaints, the Lokpal democratizes anti-corruption efforts. The RTI Act, 2005, supports this by enabling access to information for substantiating complaints, as seen in State of Uttar Pradesh v Raj Narain, 1975 Air 865, which established the right to know as part of Article 19, 1a. Asset confiscation. The Lokpal can recommend attachment and confiscation of assets acquired through corrupt means, deterring malpractices. Demerits of the Lokpal institution. Despite its merits, the Lokpal institution faces significant limitations, which undermine its effectiveness and raise concerns within administrative law. Lack of constitutional status. The Lokpal is a statutory body without constitutional backing, limiting its authority compared to constitutional bodies like the Comptroller and Auditor General. This restricts its ability to enforce decisions independently. Political influence in appointments. The selection committee includes political figures, Prime Minister, Speaker, and Leader of Opposition, raising concerns about bias. The absence of clear criteria for selecting an eminent jurist further risks manipulation. In Common Cause v. Union of India, 2017, the Supreme Court noted delays in appointments, suggesting political reluctance. Limited jurisdiction, the LPL excludes the judiciary and allegations against the Prime Minister related to international relations, security, public order, atomic energy, and space. This restricts its scope, as seen in the Uttar Pradesh tourism case, where jurisdictional limitations prevented action. Time limitation for complaints. Complaints cannot be filed after 7 years from the alleged offense, potentially allowing corrupt acts to go unpunished. Inadequate whistleblower protection. The Act lacks robust provisions to protect whistleblowers, deterring complainants due to fear of retaliation. Dependence on government agencies. The LPL relies on agencies like the CBI for investigations, which may be subject to government influence despite oversight provisions. 75. Delayed operationalization. The 5-year delay in appointing the first LPL, 2014-2019, and the absence of a director of inquiry reflect a lack of political will, undermining public trust. Relation to Administrative Law and RTI Act, 2005. The LPL operates within the framework of administrative law, ensuring that public authorities adhere to principles of legality, fairness, and transparency. Its role in investigating corruption aligns with the doctrine of accountability, a cornerstone of administrative law. The RTI Act, 2005, complements the LPL by empowering citizens to access information, enabling them to file informed complaints. For instance, Section 4 of the RTI Act mandates proactive disclosure, which supports the LPL's investigative process. In Namit Sharma v. Union of India, 2013 1 SCC 745, the Supreme Court emphasized the synergy between transparency laws and anti-corruption mechanisms, reinforcing the LPL's role. Recent developments highlight ongoing efforts to strengthen the LPL. 2024 appointment. Justice A.J. Manikro Kanwilkar's appointment as chairperson in March 2024 addressed a 2-year vacancy. First Foundation Day, 2025. The LPL celebrated its first Foundation Day in January 2025, marking its operational milestone. Jurisdictional challenges. In 2023, the LPL clarified its inability to address a complaint in the Uttar Pradesh tourism case due to jurisdictional limits, underscoring the need for broader authority. 76. Question 18, Need, Importance, Objectives and Key Features of the Rajasthan Lokayukta Act, 1973. Discuss need, importance, objectives and key features of the Rajasthan Lokayukta Act, 1973. Need for the Rajasthan Lokayukta Act, 1973. The Rajasthan Lokayukta Act, 1973, was enacted in response to growing concerns about corruption and maladministration in public administration. The need for such legislation arose from several factors: rising corruption in public administration. In the post-independence era, India witnessed an increase in bureaucratic corruption, particularly at the state level. Rajasthan, with its complex administrative structure, was no exception. The absence of an independent mechanism to investigate allegations against public functionaries necessitated a dedicated institution like the Lokayukta to curb corruption and restore public trust. Citizen grievance redressal. Citizens face significant challenges in seeking redressal for administrative wrongs, such as abuse of power or denial of services. The Lokayukta was conceived as an ombudsman to provide an accessible forum for addressing grievances, ensuring that public authorities adhere to principles of fairness and equity. Strengthening administrative accountability. Administrative law emphasizes accountability of public authorities. The Lokayukta Act was needed to enforce this principle by empowering an independent body to investigate and recommend corrective actions against erring officials, thereby reinforcing the rule of law. Case example, State of Uttar Pradesh v. Raj Narain, 1975. Although not directly related to the Lokayukta, this Supreme Court case underscored the importance of transparency in governance, a principle central to the Lokayukta's role. The court held that the right to know is implicit in Article 19, 1a, paving the way for institutions like the Lokayukta to ensure accountability. Influence of global ombudsman models. The concept of the Lokayukta was inspired by the Scandinavian ombudsman model, first established in Sweden in 1809. The Administrative Reforms Commission, 1966-70, recommended adopting such an institution in India, leading to the enactment of the Rajasthan Lokayukta Act as a state-level response to this global best practice. https://testbook.com/question-answer/when did Rajasthan Lokayukta anup Lokayukta Act 61 ed 439 said 75 d 70 cf 9 a 619, https://www.drishtayas.com/dale updates/daily news analysis/Lokayukta 77 Importance of the Rajasthan Lokayukta Act, 1973. The Rajasthan Lokayukta Act, 1973, holds immense importance in the context of administrative law and governance reform. Its significance can be analyzed through the following lenses: promoting transparency and accountability. The Lokayukta serves as a watchdog, ensuring that public authorities operate transparently. This aligns with the objectives of the Right to Information Act, 2005, which empowers citizens to access information from public authorities under Section 4. The Lokayukta complements the RTI Act by investigating cases where information disclosure reveals corruption or maladministration. Case example: Central Board of Secondary Education via Ditya Bandopadhyay, 2011. In this case, the Supreme Court upheld the disclosure of answer sheets under the RTI Act, emphasizing transparency. The Lokayukta's role in investigating related administrative irregularities reinforces the RTI Act's goal of accountable governance. https://www.lexisnexis.in/blog/Right to Information Act 2005/ Curbing Corruption by Investigating Allegations of Corruption against Ministers, Public Servants, and Officials of Autonomous Bodies. The Lokayukta acts as a deterrent. Its recommendations, though advisory, exert moral and political pressure on the government to take action, contributing to cleaner administration. Enhancing public trust. The Lokayukta provides a platform for citizens to voice grievances, fostering trust in the administrative system. Its independence from the executive ensures impartiality, making it a vital institution for democratic governance. Complementing judicial review. Under administrative law, courts exercise judicial review to check administrative actions. The Lokayukta complements this by offering an alternative, non-judicial mechanism for grievance redressal, reducing the burden on courts while ensuring administrative accountability. Case example: A.K. Krapak v. Union of India, 1970. This Supreme Court case established that principles of natural justice apply to administrative actions. The Lokayukta's quasi-judicial functions, such as conducting inquiries, align with this principle, ensuring fairness in administrative adjudication. Objectives of the Rajasthan Lokayukta Act, 1973. The Rajasthan Lokayukta Act, 1973, was enacted with clear objectives to address systemic issues in public administration. These objectives include: 78. Investigation of corruption. The primary objective is to investigate allegations of corruption, abuse of power, and maladministration by public functionaries, including ministers, secretaries, and officials of state undertakings. The Act aims to hold high-ranking officials accountable, as outlined in its jurisdiction under Section 7. Redressal of public grievances. The Act seeks to provide a mechanism for citizens to seek redressal for administrative wrongs, such as denial of services or arbitrary actions. This objective aligns with the broader goal of participatory democracy, empowering citizens to challenge administrative excesses. Promotion of good governance. By ensuring transparency and accountability, the Act promotes good governance. It encourages public authorities to adhere to legal and ethical standards, fostering a culture of integrity in administration. Support for transparency mechanisms. The Lokayukta's role in investigating corruption complements the RTI Act, 2005, which promotes transparency under Sections 4 and 6. The Act's objective of exposing maladministration supports the RTI's goal of empowering citizens with information. Case example, Union Public Service Commission v. Shiv Shankar, 2013. In this case, the Delhi High Court quashed an Information Commissioner's order under the RTI Act for lacking reasons. The Lokayukta's investigative powers can address such administrative lapses, reinforcing the objectives of both legislations. https://www.drishtias.com/to-the-point/paper4/right to information 1. Key features of the Rajasthan Lokayukta Act, 1973. The Rajasthan Lokayukta Act, 1973, incorporates several key features that define its structure, powers, and functions. These features are critical to its effectiveness as an anti-corruption institution. Institutional framework. The Act establishes the offices of the Lokayukta and Up-Lokayukta under Section 3. The Lokayukta is the principal ombudsman, while the Up-Lokayukta assists in investigations. The Chief Minister appoints the Lokayukta after consultation with the Chief Justice of the High Court, the Speaker of the Legislative Assembly, and the Leader of the Opposition, ensuring a balanced selection process. Section 3. https://testbook.com/question-answer/the term of Lokayukta in Rajasthan is 61 AF 55289 FF 13 C 79 jurisdiction. Section 7 defines the Lokayukta's jurisdiction, covering ministers, excluding the Chief Minister, secretaries and other public servants, chairpersons and officials of state undertakings and autonomous bodies. The Act excludes allegations related to judicial functions or matters pending in courts, maintaining a clear distinction between administrative and judicial domains. https://lokayukta.rajasthan.government/download term and removal. The Lokayukta's term is 5 years or until the age of 65, whichever is earlier, as amended in 2019 to align with other states. Section 5. Removal requires an impeachment motion by the State Assembly, ensuring security of tenure and independence. Section 6. https://testbook.com/question-answer/ under the provisions of the Rajasthan Lokayukta and 62 ECA 93F1F48B0BC8596FC56. https://testbook-answer/ the term of Lokayukta in Rajasthan is 61 AF 55289 FF 13 C 1081 C 31 F 81. Powers of investigation. Under Section 10, the Lokayukta can investigate complaints of corruption or maladministration, either on a citizen's complaint or suo motu, except in Uttar Pradesh, Himachal Pradesh, and Assam, where suo motu powers are absent. The Lokayukta has powers akin to a civil court, including summoning witnesses, examining documents, and requiring affidavits. Section 11. https://bijas.com/freeiesprep/lpal and Lokayukta Act 2013 / Advisory role. The Lokayukta's recommendations are advisory, not binding, under Section 12. After investigation, the Lokayukta submits a report to the competent authority, e.g., the Chief Minister for ministers or the government for public servants, which must act or provide reasons for inaction. This feature, while ensuring flexibility, limits the Lokayukta's enforcement powers. https://testbook.com/question-answer/ when did Rajasthan Lokayukta and Up-Lokayukta Act 61 Ed 439 Sed 75 D 70 CF 9/619, Complaint Procedure. Section 8 outlines the procedure for filing complaints, requiring a written application with supporting evidence. The Act allows anonymous complaints to be investigated at the Lokayukta's discretion, balancing accessibility with the need to prevent frivolous claims. https://bijas.com/freeiesprep/lpal and Lokayukta Act 2013 / 80 Independence and autonomy. The Lokayukta's independence is ensured through its appointment process, security of tenure, and financial autonomy. However, its dependence on state government funding can pose challenges to functional independence, a concern highlighted in the LPal and Lokayukta's Act, 2013, https://www.driupdates/daily-news-analysis/Lokaukta 7, linkages with RTI Act, 2005. The Lokaukta's investigations often rely on information obtained through RTI applications under Section 6 of the RTI Act. For instance, disclosures regarding public expenditure or project contracts can trigger Lokaukta inquiries, as seen in cases involving Commonwealth Games irregularities. The RTI Act's proactive disclosure mandate under Section 4(1)(b) supports the Lokaukta's role in exposing maladministration. https://www.drishtias.com/to-the-point/paper4/right-to-information 1, https://bijust.com/freeiasprep/right-to-information RTI/limitations and challenges. Despite its strengths, the Rajasthan Lokaukta Act faces challenges. Advisory nature: the recommendatory powers limit enforcement, as seen in cases where governments ignore Lokaukta reports. Exclusion of Chief Minister: the Act's jurisdiction excludes the Chief Minister, reducing its scope. Resource constraints: dependence on state funding hampers operational efficiency. https://www.dupdates/daily-news-analysis/Lokaukta 7, delay in investigations, prolonged inquiries undermine public confidence, a challenge noted in the Kerala Lokaukta's functioning. https://www.drishtias.com/daily-updates/daily-news-analysis/Lokaukta 7, Judicial and Legislative Developments. The judiciary has reinforced the Lokaukta's role in administrative law. In Justice Chandrashekhara v. Jankir C. Krishna, 2013, the Supreme Court emphasized the need for an independent Lokaukta to combat corruption, indirectly supporting Rajasthan's framework. The 2019 amendment to the Act, reducing the Lokaukta's term to 5 years, aimed to standardize tenure across states. https://testbook.com/question-answer/ under the provisions of the Rajasthan Lokaukta and 62 ECA 93F1F48B0BC8596FC56, the RTI Act, 2005, has also influenced Lokaukta investigations. In Institute of Chartered Accountants of India v. Shaunak H. Satya, 2011, the Supreme Court upheld the disclosure of professional misconduct records under the RTI Act, enabling Lokaukta inquiries into related administrative lapses. https://bijust.com/freeiasprep/right-to-information RTI/81 Question 19, Powers and Functions of Central Information Commission. Discuss powers and functions of Central Information Commission. Overview of the Central Information Commission. The CIC is a statutory body established under Section 12 of the RTI Act, 2005, comprising a Chief Information Commissioner and up to 10 Information Commissioners. Headquartered in New Delhi, the CIC oversees the implementation of the RTI Act at the central level, complementing state information commissions, 6, for state-level public authorities. Its primary mandate is to ensure that citizens' right to information, enshrined under Section 3, is upheld, subject to exemptions under Section 8. The CIC's quasi-judicial character, as affirmed in Union of India v. Namit Sharma, 2013, 10 SCC 359, enables it to adjudicate disputes impartially while promoting transparency in governance. Powers of the Central Information Commission. The CIC is endowed with a wide array of powers under the RTI Act, enabling it to enforce compliance, resolve disputes, and penalize violations. These powers, outlined in Sections 18, 19, and 20, are categorized as follows. Adjudicatory powers. The CIC exercises adjudicatory powers under Sections 18 and 19, serving as the second appellate authority for RTI applications and handling complaints against public authorities. Second appellate jurisdiction, Section 19. Under Section 19, 3, the CIC hears appeals against decisions of first appellate authorities, FAS, when applicants are aggrieved by denials, delays, or incomplete information. The CIC can direct public authorities to disclose information, subject to exemptions under Section 8. Complaint jurisdiction. Section 18. The CIC can entertain complaints regarding non-acceptance of RTI applications, unreasonable fees, or failure to provide information. It may initiate inquiries, summon parties, and issue binding orders. Case study, in Central Board of Secondary Education via Didier Bandopad 2011, 8 SCC 497, the Supreme Court upheld the CIC's order directing CBSE to disclose answer sheets under the RTI Act, affirming its authority to interpret the scope of information under Section 2, F. Investigative Powers. Section 18, 3, equips the CIC with the powers of a civil court under the Code of Civil Procedure, 1908, for inquiries, including summoning witnesses, requisitioning records, and examining evidence. These powers ensure thorough investigations into complaints and appeals, enabling the CIC to ascertain facts independently. 82 example, in a 2019 case, the CIC summoned officials of the Ministry of External Affairs to probe delays in providing passport-related information, demonstrating its investigative authority to enforce compliance. Penal powers under Section 20, 1. The CIC can impose penalties of up to Rs 25,000 on public information officers, POs, for refusing to provide information without reasonable cause, providing incomplete or misleading information, or obstructing the disclosure process. Penalties are imposed after giving the PIO an opportunity to be heard. Statistical insight. According to the CIC's 2021-22 annual report, penalties were imposed in 1,234 cases, underscoring its role in deterring non-compliance. Example, in R.K. Jain v. Union of India, 2013, the CIC penalized a PIO for deliberate suppression of information, reinforcing accountability under the RTI Act. Recommendatory powers. Section 20, 2, empowers the CIC to recommend disciplinary action against POs for persistent violations of the RTI Act. Such recommendations are directed to the concerned public authority's disciplinary body. Example, in a 2020 case involving the Department of Posts, the CIC recommended disciplinary proceedings against a PIO for repeated refusal to disclose recruitment data, highlighting its authority to ensure systemic compliance. Powers to issue directives. The CIC can issue binding directives to public authorities under Sections 19, 8, and 25, 5, to ensure compliance with the RTI Act. These include orders to disclose information, improve record management, or train POs. Case study, in Institute of Chartered Accountants of India v. Shaunak H. Sathya, 2011, 8 SCC 781, the CIC directed ICAI to disclose examination-related information, illustrating its authority to enforce transparency in professional bodies. Functions of the Central Information Commission. The CIC performs multifaceted functions to operationalize the RTI Act, ensuring its objectives of transparency and accountability are met. These functions are analyzed below. Adjudication of appeals and complaints. The CIC's primary function is to adjudicate second appeals and complaints under Sections 19 and 18, respectively. It conducts hearings, examines evidence, and delivers reasoned orders, functioning as a quasi-judicial body. The CIC's decisions are binding, subject to judicial review by high courts or the Supreme Court under Articles 226 or 32. 83 example, in a 2018 case, the CIC directed the Prime Minister's office to disclose details of the PM Cares Fund, demonstrating its role in resolving high-profile disputes. Promoting proactive disclosure. Under Section 25, the CIC monitors compliance with Section 4, which mandates public authorities to proactively disclose information, such as organizational details, budgets, and policies. The CIC issues guidelines and conducts audits to ensure adherence. Example, in its 2020-21 annual report, the CIC noted that 78% of central public authorities complied with proactive disclosure norms, reflecting its supervisory role. Reporting and Policy Recommendations Section 25, 1, mandates the CIC to submit annual reports to Parliament, detailing RTI implementation, case disposal, and compliance levels. These reports include recommendations for legislative or administrative reforms to strengthen the RTI regime. Statistical Insight: the 2021-22 CIC Annual Report recorded 136,922 appeals and complaints, with a disposal rate of 89%, highlighting its robust monitoring function. Training and awareness: the CIC facilitates training programs for POs and FOs to enhance their capacity to handle RTI applications. It also conducts public awareness campaigns to educate citizens about their rights under the RTI Act. Example: in 2022, the CIC collaborated with the Department of Personnel and Training to train 5,000 POs, improving RTI compliance across central ministries. Ensuring compliance with exemptions: the CIC interprets and applies exemptions under Section 8, ensuring a balance between transparency and legitimate restrictions, such as national security or personal privacy. It scrutinizes claims of exemption to prevent misuse. Case study: in Registrar, Supreme Court of India v. Subhash Chandra Agarwal, 2019, 5 SCC 689, the Supreme Court upheld the CIC's order to disclose judicial appointment records, rejecting blanket exemptions under Section 8, 1, J. Interplay with administrative law: the CIC operates within the framework of administrative law, embodying principles such as fairness, accountability, and judicial review. Its quasi-judicial nature aligns with the characteristics of administrative tribunals, as clarified in Bharat Bank Limited v. Employees, AIR 1950 SC 188, where the Supreme Court recognized quasi-judicial bodies as entities performing judicial functions without being courts. 84. Fairness and natural justice: the CIC adheres to principles of natural justice, ensuring that parties are heard and decisions are reasoned. Section 18, 4, mandates that inquiries follow fair procedures, protecting applicants and POs alike. Example: in a 2017 case, the CIC set aside a PO's refusal to disclose information due to lack of opportunity to be heard, reinforcing procedural fairness. Accountability in public administration: by enforcing transparency, the CIC holds public authorities accountable for their actions, aligning with administrative law's emphasis on preventing arbitrary governance. Its penal and recommendatory powers deter maladministration. Case study: in Delhi Development Authority v. Skipper Construction Co., 1996, 4 SCC 622, the Supreme Court emphasized the need for transparency in public dealings, a principle advanced by the CIC's functions. Judicial oversight: CIC decisions are subject to judicial review by high courts under Articles 226 and 227, ensuring compliance with constitutional norms. In Union of India v. Namit Sharma, the Supreme Court clarified that the CIC's quasi-judicial role does not exempt it from judicial scrutiny. Critical analysis: the CIC has significantly advanced the RTI Act's objectives, empowering citizens and enhancing governance transparency. However, it faces challenges: pendency of cases. As per the 2021-22 annual report, the CIC had a backlog of 38,116 cases, attributed to vacancies and limited infrastructure. Limited enforcement powers: the CIC lacks contempt powers, weakening its ability to enforce compliance by recalcitrant public authorities. Inconsistent exemption application: variations in interpreting Section 8 exemptions lead to unpredictability, necessitating clearer guidelines. Executive influence: appointments under Section 12, 3, controlled by the central government, raise concerns about independence, despite judicial oversight. The RTI Act's synergy with the CIC strengthens administrative law principles, but amendments are needed to address vacancies, enhance enforcement, and standardize exemption applications. The proposed RTI Amendment Bill, 2019, which sought to alter CIC tenure and salaries, sparked concerns about undermining autonomy, highlighting the need for reforms that preserve independence. 85 Question 20, Key features of the Central Vigilance Commission Act, 2003 and Right to Information, Amendment, Act, 2019. Briefly explain the key features of the following. I. The Central Vigilance Commission Act, 2003. 2. Right to Information, Amendment, Act, 2019. Key features of the Central Vigilance Commission Act, 2003. The Central Vigilance Commission Act, 2003, enacted on September 11, 2003, conferred statutory status on the Central Vigilance Commission, CVC, originally established in 1964 based on the Santhanam Committee's recommendations. The Act aims to combat corruption in public administration by empowering the CVC to oversee vigilance activities and inquire into offences under the Prevention of Corruption Act, 1988, POCA. Its key features are discussed below. Composition and Appointment. Section 3 of the CVC Act establishes the CVC as a multi-member body, comprising a Central Vigilance Commissioner, CVC, as chairperson and up to 2 Vigilance Commissioners. Appointments are made by the President on the recommendation of a committee consisting of the Prime Minister, Chairperson, the Minister of Home Affairs, and the Leader of the Opposition in the Lok Sabha. Section 4. Members must have expertise in vigilance, policy making, administration, law, or finance, ensuring a balanced composition. Case study, in N. Kannadasan v. Ajoikos, 2009, 7 SCC 1, the Supreme Court emphasized that CVC members must be individuals of impeccable integrity, interpreting the eligibility criteria under Section 3(3)(a), to exclude those with blemished records. Tenure and removal. Section 5 stipulates that the Central Vigilance Commissioner and Vigilance Commissioners hold office for 4 years or until they attain the age of 65, whichever is earlier. Removal is permitted only by the President on grounds of proved misbehavior or incapacity, following a Supreme Court inquiry. Section 6. Example, the Supreme Court's ruling in Centre for Pill v. Union of India, 2011, 4 SCC 1, quashing the appointment of P.J. Thomas as Central Vigilance Commissioner due to pending charges, underscored the stringent removal provisions to ensure integrity. Functions and powers. The CVC's functions, detailed in Section 8, include superintendence over CBI. The CVC exercises superintendence over the Delhi Special Police Establishment, CBI, for investigations under the POCA, ensuring independent probes. 86 Advisory role. The CVC advises central government organizations on vigilance policies, planning, and reforms to prevent corruption. Inquiry into complaints. Under Section 8(1)(d), the CVC can inquire or cause inquiries into allegations of corruption or misuse of office. Example, in Vineet Narain v. Union of India, 1998, 1 SCC 226, the Supreme Court directed the government to grant statutory status to the CVC to enhance its autonomy, leading to the 2003 Act. Whistleblower protection. Since 2004, the CVC has been designated as the agency to receive complaints under the Public Interest Disclosure and Protection of Informers Resolution, PIDP, ensuring whistleblower anonymity. Section 11. The Whistleblowers Protection Act, 2014, further reinforced this role. Example, in 2019, the CVC protected a whistleblower from a public sector bank who exposed financial irregularities, demonstrating its commitment to safeguarding complainants. Jurisdiction and limitations. The CVC oversees vigilance in central government organizations, public sector undertakings, and government companies. However, it lacks direct investigative powers and relies on the CBI or Chief Vigilance Officers, CVOs, for investigations. Section 8(2). The CVC's role is advisory, and it cannot direct CBI investigations, limiting its enforcement capacity. Statistical insight. The CVC's 2019 annual report noted 72 recommendations for criminal proceedings, highlighting its supervisory role despite limited direct powers. Amendments and expanded roles. The LPL and Lokauktas Act, 2013, amended the CVC Act to empower the CVC to conduct preliminary inquiries into LPL-referred complaints for Group A, B, C, and D officers, enhancing its investigative role. Case study, in Ram Jethmalani v. Union of India, 2015, the Supreme Court scrutinized the CVC's inquiry into LPL-referred case, emphasizing its accountability to judicial oversight. Independence and accountability. The CVC is an independent body, free from executive control, and reports directly to Parliament, Section 3. Its autonomy was reinforced by the Supreme Court's directive in Vineet Narain to ensure impartial functioning. 87 Key features of the Right to Information, Amendment, Act, 2019. The Right to Information, Amendment, Act, 2019, introduced on July 19, 2019, and passed by Parliament, amended the RTI Act, 2005, to rationalize the tenure, salaries, and service conditions of the Chief Information Commissioner, CIC, and Information Commissioners, ICS. The amendments sparked debates over potential government control over the RTI framework. The key features are analyzed below. Modification of tenure. The RTI Act, 2005, prescribed a fixed 5-year term for the CIC and ICS at central and state levels, Section 13. The 2019 amendment, Section 2, removes this fixed term, allowing the central government to prescribe the tenure through rules. Implication: critics argue this grants the government flexibility to influence the independence of information commissioners by altering tenures on a case-by-case basis. Salary and allowances. Under the original RTI Act, the CIC salary was equivalent to the Chief Election Commissioner, and IC's salaries matched election commissioners, central level, or the Chief Secretary, state level. The 2019 amendment, Section 3, empowers the central government to determine salaries, allowances, and other service conditions through rules. Case study, in Namit Sharma v. Union of India, 2013, 10 SCC 359, the Supreme Court emphasized the quasi-judicial independence of the CIC, raising concerns that the 2019 amendment's salary provisions could undermine this autonomy. Pension deductions. The amendment modifies Section 13(3) to state that pensions or retirement benefits from previous government service will reduce the salaries of the CIC and ICS, applicable to service under central/state governments, public corporations, or government companies. Example: this provision ensures fiscal prudence but may deter qualified candidates with prior government service from accepting CIC or IC roles. Rationale and objectives. The statement of objects and reasons for the 2019 amendment cites the need to rationalize the status of information commissioners, noting that their mandate differs from the Election Commission, and their decisions are subject to High Court review, unlike Supreme Court judges. The amendment aims to correct these anomalies. 88 Critical perspective. RTI activists, as noted in PRS legislative research, criticized the amendment for potentially weakening the CIC's independence by aligning its status with bureaucratic rather than judicial benchmarks. Impact on transparency. The RTI Act, 2005, mandates transparency through proactive disclosure, Section 4, and citizen access to information, Section 6. The 2019 amendment does not alter these core provisions but affects the CIC's operational autonomy, potentially impacting its enforcement capacity. Example: in Central Board of Secondary Education v. Aditya Bandyopadhyay, 2011, 8 SCC 497, the Supreme Court upheld the CIC's authority to enforce transparency, a principle that could be challenged if government control over CIC terms increases. Interplay with administrative law. Both the CVC Act, 2003, and the RTI Amendment, Act, 2019, operate within the framework of administrative law, emphasizing accountability, transparency, and fairness. Accountability and anti-corruption. The CVC Act aligns with administrative law's goal of preventing arbitrary executive action by overseeing vigilance and corruption investigations. Its advisory and supervisory roles ensure checks on administrative power. Example, the CVC's role in advising disciplinary action in a 2020 case against a corrupt railway official exemplifies its contribution to administrative accountability. Transparency and public participation. The RTI Act, 2005, and its 2019 amendment enhance public participation by ensuring access to information. However, the amendment's provisions on tenure and salaries raise concerns about the CIC's independence, a key administrative law principle. Case study, in Registrar, Supreme Court of India v. Subhash Chandra Agarwal, 2019, 5 SCC 689, the Supreme Court upheld the CIC's order for judicial transparency, highlighting the RTI Act's role in democratic governance. Judicial oversight. Both the CVC and CIC are subject to judicial review under Articles 226 and 227, ensuring compliance with constitutional norms. The Supreme Court's rulings in Vineet Narain and Namit Sharma underscore this oversight, balancing autonomy with accountability. 89. Critical analysis. The CVC Act, 2003, strengthens anti-corruption mechanisms but faces challenges due to its limited investigative powers and reliance on external agencies like the CBI. The Vineet Narain case highlighted the need for greater autonomy, partially addressed by the Act, but issues like delayed permissions for investigations persist. The RTI Amendment Act, 2019, aims to streamline the RTI framework but has been criticized for potentially undermining the CIC's independence. The removal of fixed tenures and government control over salaries could weaken the quasi-judicial authority of the CIC, as noted in Namit Sharma. Both acts enhance transparency and accountability but require reforms to address operational bottlenecks and ensure independence. 90.